Testing 1, 2, 3, 4, 5. Testing 1, 2, 3, 4, 5, 6.
The Select Investigative Panel will come to order, and before we begin, I would like to take a moment to address the guests who are in our audience today. First of all, we thank each of you for taking the time to come. We think that engaged citizens are a welcome and valuable part of the political process. I only wish every hearing drew the amount of interest that this hearing has drawn. For the purpose of this hearing, we are going to be examining the pricing of fetal tissue. It's an opportunity for the Select Investigative Panel to ask questions and have a thoughtful discussion. The number of people in the audience this morning demonstrates the strong interest in the topic, and we welcome you. I do want to remind our guests in the audience that the chair is obligated under the rules of the House and the rules of the committee to maintain order and preserve decorum in the committee room. And I know that we all have deep feelings on the issue, but we appreciate the audience's cooperation in maintaining order as we have a full discussion that we'd like to have this morning on this important issue. I also want to welcome each of our witnesses who are here today. And at this time, I am going to yield myself 10 minutes for an opening statement.
Madam Chair,
Thank
you, Madam Chair. Regretfully, I need to bring up an issue regarding to the packet of materials, the so-called exhibits that was provided to your staff yesterday before the opening statements. And the reason is because we have just received your opening statement, which was released to the press. I just saw it for the first time. And in your opening statement, you make extensive reference to this package of so-called exhibits. And so before you make your opening statements, maybe we can resolve the issues. Otherwise, we're going to even have to object to the documents referenced in your opening statement. And if I may, Madam Chair, I'll go over what our issues are with those so-called exhibits. Your staff told us that you and other Republican members intended to use these materials to question witnesses today, and it's my understanding that these documents have been given to the witnesses. In fact, several of the witnesses mentioned the documents in their written statements. Now, I reviewed the documents yesterday. Some of them were created wholesale by Republican staff. There was no explanation of the underlying factual foundation for those materials, the methodology that was used in coming up with these charts or some of the graphs that we had. And frankly, I believe them to be misleading. And moreover, the conclusions that are drawn and frankly stated as fact in the staff-created annotated index are false. There were other documents that were sourced to a, quote, procurement business, which also have nothing to do with the topic of this hearing, although they were presented as if they did. They don't distinguish between the various services of the company, which provides a variety of different specimens, including adult blood and bone marrow, for use in biomedical research. Now, just to add to this, Madam Chair, yesterday, the company who we believe these so-called exhibits came from, STEM Express, sent a letter to you and a copy to us about the serious problems with these so-called exhibits. I'd ask unanimous consent to put that into the record. But I guess my point is, I'm concerned because the so-called exhibits, I don't think they're really designed to find the facts about fetal tissue research. If they were, we would have called STEM Express in, or we would have taken depositions. And I don't believe that they're germane as required by Rule 16, Clause 7 of the House, because they don't reflect credibility, but instead they cast dishonor on the House. But you know, in addition, if I just may, because we just got these exhibits yesterday and then we got the letter from STEM Express, it has really it also raises troubling questions about where this material came from. If you look at STEM Express's letter, and I hope you've read it, Madam Chair, what it says is that what STEM Express is saying is they believe that the panel may have received material directly from Mr. David DeLayden that have not been authenticated and that were obtained by Mr. DeLayden unlawfully. This is part of the whole issue of the investigation in Texas, and some of these even may have been created by Mr. DeLayden themselves. And what the company did was they asked that we withdraw these documents until the General Counsel of the House of Representatives, Carrie W. Kircher, has an opportunity to review them and approve their list. And so, Madam Chair, given the concerns about the factual foundations of these exhibits, and also given the further concern about how they were created, what they're saying, I would just ask if we could withdraw these exhibits until these things are figured out.
I thank the gentlelady for her inquiry. Yes, we were in receipt of the letter. I don't know anything about the attorney or how truthful their letter is. We do intend and will accept, I accept your request, and we will UC that letter into the record and for the hearing today. The documents, let me speak to that for a moment. The documents have all been obtained through our regular investigatory work. We have had things that have come to us from whistleblowers, from subpoenas, from former employees, citizens that have filed FOIA requests, the panel's whistleblower portal, as I said, and also an internet search archive search engine. And that is the way these documents have come to us. So the documents that we're going to use for the hearing, or the documents that we intend to use for the hearing, we will accept and UC the letter into the record. And with that,
Madam Chair, may I make a further parliamentary inquiry?
Parliamentary inquiry. Go ahead.
Madam Chair, you had just stated that all of the documents that formed the basis of these exhibits were received from a variety of sources by the committee, including whistleblowers. Have all of those documents and their sources been provided to the minority staff of this committee?
We have provided documents to the minority staff.
Have you provided all of the documents, Madam Chair, that you referred to that were used as the foundation for these exhibits?
I think all of those documents have been provided to you, and then you all leaked, you had staff that leaked the documents to one of the entities.
Okay, so they've all been, okay. Madam Chair, I would ask a further parliamentary inquiry then. Before we continue then, might I be asked to inquire of the appropriate staff member of the foundational basis for these exhibits, particularly Exhibit B1, B2. Some of those, there's a chart, Exhibit B4, which you intend to use. There's an Exhibit B6, excerpt of a draft contract between the PB and Abortion Trade Association, which appears to have been created by staff. I'd like to be able to ask the staff how these documents were created and what
do you mean by foundational basis?
Well, for example, Madam Chair, if you take a look at Exhibit B1. So Exhibit B1, Madam Chair, appears to be a chart, and it has three boxes: abortion clinic, procurement, business, researcher, and between the three boxes there are dollar signs and arrows going back and forth. There are questions and so on. I don't know what information this is based on. I don't know. I'd like to know how this was created. Or if you look at Exhibit B2, for example, Exhibit B2 is some document. It doesn't say where it's from. It appears to have been taken from some website, but this is one of the documents that STEM Express is saying that they think might have been taken from not from their company, but from someplace else, and not talking about fetal tissue. But I don't know where that comes from. The exhibit is not identified where it comes from, but I suspect that the witnesses today and the majority intend to somehow try to use this to talk about the so-called sale of fetal tissue. Exhibit 3 is just, again, something taken off a website. We don't know the source of that. Exhibit 4 appears to be a bar graph, and what it says is procurement business, clinic growth strategy, number of partnerships with abortion clinics, then it's got a bar graph. Then Exhibit 5, B5, procurement business revenue growth, then it's got another bar graph, but we don't know who made those bar charts, and we don't know where that information came from. So if you or the witnesses are relying on this, this is being presented as if it's a fact, but in fact it's not. And then B6, this is one that particularly disturbs me. It says, in parentheses, excerpt of a draft contract between the PB and the abortion
If the gentlelady
trade.
will yield.
Yeah, sure.
Okay. The B1 graph that you're referencing was created by staff for discussion purposes. It's created by material that, that has been submitted to us, to the committee. And so the document B2 exhibit that you're going to is something, again, that was submitted to us. And B4 is something created by staff from material that has been submitted. Now, does the gentlelady have a motion?
Just to finish my statement, Madam Chair, that's my concern. I'd like to be able to question the staff member who created all of these documents. I assume,
They're
Madam Chair,
created for
B6.
discussion, and if you'd like to include in your questioning in your time, discussion about
Well,
that,
Madam
that
Chair,
is
I
fine.
think that these exhibits were created from whole cloth, and if you won't let me find out what the basis for these are, then I object to the use of any of these exhibits, and I would make a
lady that information has been submitted to us.
And I would make a point of order that these materials are against the Rule 16, Clause 7 of the House, and I would ask for their exclusion.
Madam Chair, I'd move to table the point of order.
The gentlelady's motion has been.
Madam Chair, I appeal the ruling of the chair.
The gentlelady's motion has been made, and the motion is tabled. All of
Madam
those-
Chair, I appeal the ruling of the chair.
Well,
That was the motion I just made, Madam Chair.
you made the motion to exclude.
No, and then he moved to
motion
table it,
to-
and then I moved to appeal, and then you ruled, you moved to table it, and I moved to appeal it.
We will rule on the motion to table first,
Yes.
okay? And the motion is tabled.
I appeal the ruling of the chair.
And the appeal.
And I ask for a
And-
recorded vote.
And the appeal is denied. We will have the clerk recall the roll on for the recorded vote on the motion to appeal.
Mr. Pitts?
Yes.
Mr. Pitts says A. Ms. Black? Ms. Pitts says aye. Ms. Black says aye. Mr. Bouchon? Mr. Bouchon says aye. Mr. Duffy?
Aye.
Mr. Duffy says aye. Mr. Harris? Aye. Mr. Harris says aye. Ms. Hartzler?
Aye.
Ms. Hartzler says aye. Ms. Love?
Aye.
Ms. Love says aye. Ms. Schakowsky?
No.
Ms. Schakowsky says nay. Mr. Nadler? Ms. DeGette? Ms. DeGette says nay. Ms. Spear? Ms. Spear says nay. Ms. Delbene? Ms. Delbene says nay. Ms. Watson-Coleman? Ms. Watson-Coleman says nay. Madam Chair,
Aye.
Madam Chair says aye.
Clerk will report the tally.
Chairman Blackburn, on the vote, there were 8 ayes and 5 nays.
The motion to exclude is tabled. At this time, I will begin
Wait,
the opening statement, and we will then move to our first panel of witnesses who have come.
Madam
into the
Chair, I really want to ask at this point that your words be taken down regarding the assertion that staff, quote, leaked documents to the entity, actually it's to STEM Express. These documents had already been given to witnesses and the press, and then were posted to your website. So I think your words need to be taken down. Accusing our staff of leaking that is not true, and those words should be taken down.
Madam Chair.
Ms. Schakowsky, the staff had asked for the documents. They were shared. This was shared before they went to the website, and then they were released to the entity. And in order to take the comments down, the comments have to be personal in nature. So with that, let's begin with our opening statements, and then we will receive our first panel of witnesses. As I was beginning earlier, I want to welcome all of our witnesses who are here today. I am going to introduce each of you later as we move forward with our testimony on the pricing of fetal tissue. As part of my opening statement, I will present a narrative about the exhibits that today's hearing will discuss. I've said many times, my hope is that both parties can work together on some things, and today's subject matter should be an opportunity to do so for a couple of reasons. First, at our initial hearing on bioethics in fetal tissue, all witnesses from both sides agreed that no one should profit from the sale of baby body parts. Nobody. Second, the Democrats overwhelmingly supported a prohibition on profiting from fetal tissue sales during the 1993 passage of the National Institutes of Health Revitalization Act. Former Congressman Dingell passed this legislation out of the Energy and Commerce Committee, and former Congressman Henry Waxman amended the NIH bill on the floor to make clear that profiting from the sale of baby body parts was a crime. Folks, these two Democrat leaders took the offense so seriously that they made profiting from the sale of fetal tissue punishable by a 10-year felony. They understood that unborn children do indeed have constitutional rights. Now, there's been a lot of heated debate about the horrible videos that came out last year, but today's hearing will present business documents, invoices, marketing brochures, and management documents that reveal that one for-profit procurement business and several abortion clinics may have violated the intent of the statute, and the Waxman prohibition passed overwhelmingly by a Democrat-controlled House. We have invited former U.S. attorneys and others to help us understand this conduct in light of the existing statute. We look forward to working through this material in a thoughtful way, and I ask my colleagues on the other side to join in a productive discussion about the statute that your side passed. Before I turn to introducing the documents, I want to call your attention to 5 posters that will help to visually follow the discussion. The first chart presents 3 entities involved in the business of selling the body parts. That chart depicts that the middleman, the procurement business, pays the abortion clinic for fetal tissue and is then paid by the researcher or the customer. The second chart is a website screen grab from the procurement business of how to buy baby body parts online. Now, there's a new website, and the baby body parts procurement business has been spun off to a new entity. That chart shows the drop-down box for every part imaginable: heart, eyes, scalp, liver, hands. Then you click on the next box and you pick the gestation period. Then you click and proceed to checkout to select your form of shipping. The third chart shows the daily task performed by the procurement business employee inside the abortion clinic. Once the order is communicated, the procurement tech starts her work checking gestation periods, getting consent, procuring tissue, and sending to the customer. These are clear HIPAA violations. Our Democratic colleagues have voiced concerns over privacy throughout the investigation. I would hope at a minimum they will join us in condemning obvious violations of HIPAA, which was signed into law by President Clinton on August 21st of 1996. The fourth chart summarizes several sample actual payments from the procurement business to the abortion clinic and from the customer to the procurement business. These are just samples for our discussion today. They do not present the entire financial picture. And the fifth chart shows who bears the responsibility for the reasonable cost involved in the procurement and sale. Next, I want to walk the witnesses through the exhibits. I know that all the lawyers in the room like to focus on every detail, and that is why you are here. But it is also important to understand the big picture of what the procurement business was trying to do, especially in light of the Waxman prohibitions against profiting from the sale of baby parts in the '93 NIH Revitalization Act. Please turn to the B exhibits, beginning with B2. This is the procurement company brochure that is handed out at national conferences where abortion clinic managers were in attendance. Notice it says financially profitable, fiscally rewards, financial benefit to your clinic. Look at Exhibit B3, which is a website screen grab of the procurement business. Once again, financially profitable, while also providing a financial benefit to your own clinic. Evidently, the procurement business is not familiar with the Waxman prohibition. Now turn the page and look at Exhibits B4 and 5. The procurement business started in 2010 with 3 clinics. 2 years, it was up to 30, and in 2 more years, it had nearly 100. Further, they were negotiating a contract to have over 250 clinics by this year. But the co-marketing negotiations with the National Abortion Trade Organization fell apart just about the time the videos came out last year. Now, you do not have to be a lawyer to see what's going on here. You put up a website that offers the parts imaginable, and why on earth would anybody ever need a baby scalp? Then you pick the gestation period and you check out. To offer that service, you need abortion clinics, a lot of abortion clinics. So you grow your number of clinics and you offer the clinics money to sign up. You offer them financial benefit to join. You tell the clinic that you will do all the work, all the items on the chart that show the workflow of the procurement technician. This does not sound to me like tissue donation for research. This sounds like someone who wants to make money, a lot of money, selling the baby body parts. So I thank our witnesses for their generous time today. I welcome them, and at this time, I yield 10 minutes to Ms. Schakowsky.
From the outset, this investigation has not been an objective or fact-based search for the truth, but a political weapon to attack women's health care and life-saving research and harass and intimidate those who provide these services. This was clear during our first hearing, where one of the witnesses invited by the Republicans drew comparisons between researchers who use fetal tissue and Nazi war criminal Dr. Joseph Mengele, a comparison echoed by Chair Blackburn in her opening statement. Another Republican witness testified that women who have abortions are, quote, morally disqualified, unquote, from choosing to donate tissue for research purposes. For today's hearing, Republicans have again invited witnesses who believe that abortion should be illegal, that women should not be permitted or trusted to decide whether to carry a pregnancy to term, Some continue to declare that Planned Parenthood is selling fetal tissue, as you just heard, for profit, despite the fact that 3 House committees, 12 states, and a Texas grand jury have already cleared the organization of wrongdoing. These witnesses, like our Republican colleagues, endorse and rely upon the video allegations of anti-abortion extremist David Daleiden and his associates to support their inflammatory claims. Anyone who has been following the facts knows the truth. Mr. Daleiden's videos are not accurate or reliable, and they do not show the unlawful sale of fetal tissue, and we will argue today that these so-called exhibits do not make that case either. A grand jury in Texas already put Mr. Daleiden to the test under oath, and he failed. That grand jury, instructed by the Republican lieutenant governor to investigate Planned Parenthood, instead indicted Daleiden for breaking the law through his efforts to entrap Planned Parenthood. The district attorney handling the case refused to represent it to another grand jury, explaining that, quote, "We must go where the evidence leads us," unquote. And as she explained, and I quote, "Anyone who pays attention knows that I'm pro-life. I believe abortion is wrong, but my personal belief does not relieve me of my obligation to follow the law," unquote. That standard should apply with equal force here. There is no reason to believe that Daleiden, a proven liar when it comes to Planned Parenthood, would be any more truthful about anyone else involved in reproductive health care or fetal tissue research. Yet, instead of correcting the record on the Daleiden videos, the chair continues to invoke them. Today, my Republican colleagues likely will claim that it is not just the videos, actually. She has claimed, the chair has already claimed that. They may assert that documents that this panel has received or that Republican staff have created show the need for further investigation, and this is also false. 16 years ago, the Subcommittee on Health and Environment of the House Commerce Committee considered similar materials 16 years ago. That hearing, titled, quote, "Fetal Tissue, Is It Being Sold in Violation of Federal Law?" unquote, featured a, quote, fee-for-service schedule, unquote, showing amounts charged for types of tissue, quote, transaction logs, unquote, with charges for tissue on particular dates, and agreements between providers and procurement organizations. And that hearing also featured an employee, Dean Alberti, who had worked at 2 tissue procurement organizations. The anti-abortion group, quote, Life Dynamics, unquote, had filmed and released a video interview, well, where, is it Alberti claimed to have witnessed fetuses, quote, born alive, unquote, doctors changing procedures for donation purposes, and unlawful payment for fetal tissue, exactly the types of claims made in the Daleiden video. In statements under oath, however, Alberti contradicted his inflammatory claims and admitted during the 2000 hearing that his sworn statements, not the remarks on the heavily edited video made by anti-abortion extremists, were the truth. The Department of Justice also investigated the allegations of unlawful profiteering that was at the heart of that hearing and concluded that no laws had been broken. No one believes that companies should be allowed to profit by selling fetal tissue, and we firmly support the prohibition. However, just as it does for adult organ donation, the law expressly allows reimbursement for cost. In fact, 42 U.S.C. 289G, the provision that we are focusing on today, is modeled on the National Organ Transplant Act, which similarly prohibits, quote, valuable consideration, unquote, but allows reimbursement for costs associated with organ donations, which can be considerable. Allegations regarding possible unlawful profit from adult organ transplantation would not result in a call to ban all organ donations, yet Republican lawmakers in the House want to ban fetal tissue donation and research altogether, something that some states have already done. Florida, for example, recently enacted a sweeping bill attacking women's health care and banning the donation of fetal tissue. This is tragic for women and families in the Gulf Coast as summer approaches and researchers race to understand and solve the Zika virus. Despite Chair Blackburn's claim that Democrats are exaggerating, she says, its importance, key studies have relied heavily on fetal tissue to increase our understanding of the Zika virus. These bans have been proposed despite the fact that there still is no evidence of wrongdoing related to fetal tissue donation. Instead, the documents received by this panel actually show that healthcare providers are losing money through programs that allow women to donate fetal tissue for research purposes. This was not what Congress intended when it voted on a bipartisan basis to allow reimbursement of costs. It is absurd that even when they are losing money, providers are still attacked by those who appear to be motivated by their opposition to abortion, not the actual facts regarding fetal tissue donation. This panel is a perfect example. Over the course of the investigation, the chair has targeted one clinic, one university, and one tissue procurement organization, all of whom were cooperating voluntarily before the chair served them with unilateral subpoenas. The panel has known since January that Southwestern Women's Options does not take any money for ensuring that women who want to donate tissue to the university can do so. And let me underscore that fact: no money is exchanged in connection with a woman's choice to donate fetal tissue to researchers at the University of New Mexico. Already knowing this, the chair served subpoenas and issued press releases tying them to what she repeatedly described as an investigation into the unlawful sale of baby body parts, words we heard today. As a result of the university and clinic have been subject to unwarranted accusations from state and federal officials and additional targeted harassment from anti-abortion extremists, is it any wonder that universities, clinics, and others reluctant to hand over the names of their researchers, students, clinic personnel, and doctors so that the chair can amass a dangerous database of their names? For its part, the tissue procurement company STEM Express already offered to have its procurement director explain its cost structure. The chair ignored that offer and instead called this public hearing and invited witnesses who have no firsthand knowledge of the facts to opine about potential criminal misconduct. On its own initiative, STEM Express has now submitted a letter to ensure that the panel has the information needed to bring this investigation to an end. This investigation has never been and has no promise of becoming fair or fact-based. Our Republican colleagues' disdain for the facts and for women and their doctors is putting researchers, doctors, and women at risk. It is time for Republican leadership to bring this investigation to an end. I ask unanimous consent to have the April 18th letter from STEM Express included as part of the record for this hearing and yield back the balance of my time.
The gentlelady yields back. On her UC request, we had already agreed to put that into the record. At this time, I want to welcome our first panel. Senator Jean Shaheen is a U.S. Senator from New Hampshire. She's the only woman in U.S. history to be elected both a governor and a U.S. Senator.
Excuse me,
Senator
can I just say the
Shaheen?
letter I wanted inserted in the record is a different letter that we received from yesterday. So
So
if you could,
moved.
okay.
So moved.
Sorry.
Senator Shaheen has served in the U.S. Senate since '09 and is a member of the Senate Committees on Armed Services, Foreign Relations, Appropriations, and is ranking member of the Small Business and Entrepreneurship Committee. Senator Shaheen is a former small business owner and formerly served as the director of Harvard University's Institute of Politics at the Kennedy School of Government. Welcome. Senator Ben Sasse is a U.S. Senator from Nebraska. Senator Sasse comes to the Senate having spent the last 5 years as a college president, one of the youngest in the nation. During the first and second terms of President George W. Bush, he worked in the Department of Justice and the Department of Homeland Security before becoming Assistant Secretary for Planning and Evaluation at the U.S. Department of Health and Human Services. Welcome to you, Senator Sass. At this time, we will begin with Senator Shaheen for your 5-minute remarks, and we welcome you.
Thank you very much, Chairwoman Blackburn and Ranking Member Schakowsky, members of the committee. I very much appreciate the opportunity to appear before you this morning, but I do so with great concern. I know you will hear from my colleague, Senator Sass from Nebraska, and I respect his deeply held personal beliefs. But if we want to have a civil discussion on this issue, we should begin with the facts. Already, news articles today have called into question the validity of the exhibits that will be presented to the panel. This committee's very existence was founded on the basis of highly deceptive, edited videos. These videos have since been proven to be misleading and false by multiple independent investigations across the country. In January, after thorough investigations into the videos, a Texas grand jury cleared Planned Parenthood of any wrongdoing and indicted the individuals responsible for their creation. In fact, 12 other states have also cleared Planned Parenthood of any wrongdoing, and 8 additional states have declined to investigate, citing a lack of evidence. I believe it's now time for the special investigations to end. And I'd also like to point out that fetal tissue research has long had bipartisan support. In 1993, Congress passed the National Institutes of Health Revitalization Act, which permits fetal tissue research. That bill passed with overwhelmingly support, 94-4 in the Senate and 290-130 in the House. And I think it's important to note that that bill was passed on recommendations of a blue ribbon panel convened under President Reagan, which was tasked with studying the ethics of fetal tissue research. Millions of people have benefited from fetal tissue research. Vaccines for polio and rubella were developed as a result of research done on fetal tissue, and research on health issues that touch so many of us: Parkinson's disease, diabetes, HIV/AIDS, eye disorders, and spinal cord injuries have also benefited from the 1993 law. If it's the panel's desire to change the law, obviously you as legislators are able to do that. But I believe it would be a grave error. Sadly, it's my belief that this panel was formed with political motivations. There is very little real interest in an unbiased investigation to uncover facts related to women's health or research. Instead, I believe that this panel serves as an opportunity for some to once again attack the healthcare providers whom millions of women and families depend on. In February, I joined with colleagues in both chambers to ask House and Senate leadership to disband this panel and all other congressional investigations that would undermine women's access to health care. Not only do I believe that this panel is an inappropriate and wasteful misuse of federal resources, but I'm gravely concerned that it also puts researchers, providers, and patients across the country at risk. Unfortunately, as a result of the political rhetoric surrounding this issue, we've seen violent acts and threats against women health providers and researchers across the country. And I'm very sad to report that this fall, the same month that this panel was formed, a women's health clinic in Claremont, New Hampshire, was vandalized not once, but twice. The second attack caused so much damage that the clinic was forced to close for nearly 6 weeks, and this was a real disservice to the women, men, and families who rely on the full range of services that the clinic provides. And unfortunately, New Hampshire is not alone. After the release of the deceptive, highly edited videos, incidents of harassment against some health centers increased 9-fold in just 1 month. I don't believe that today's hearing is a fact-based, objective investigation, but rather it is a taxpayer-funded political attack based on discredited evidence. I hope it will finally be time to move on. And Madam Chair, if I could apologize for the need to leave early and go back to a hearing. I appreciate, again, the opportunity to be here. Thank you.
We thank you so much, and we know that you do have to leave and get back, that you all are having votes this morning, but thank you for the courtesy of your time and for waiting for us. Senator Sash, you are recognized for 5
Let me just thank the Senator Shaheen as well. I appreciate your being here.
Thank you, Madam Chairman. Good morning, Ranking Member. Thank you for including me. Many of us in the Senate, like many of you in the House, and more importantly, like millions of Americans, watched with grief the video footage of abortion doctors and others discussing the sale of baby body parts for profit. As a legislator, but more importantly as a father, I have 3 little kids, 3 precious ones. One of my little girls traveled with me from Nebraska to D.C. this week, and she's here with us today. More importantly, as a father, I support your investigation and your commitment to get to the bottom of what's going on here. Let's begin by stating clearly that we should not have to be here today. The 1993 NIH Revitalization Act includes a testimony where California Democrat Henry Waxman said, and I quote, "This amendment that I am offering would enact the most important safeguards to prevent any sale of fetal tissue for any purpose, not just for the purpose of research. Any sale for any purpose. It would be abhorrent," Waxman continued, "to allow for the sale of fetal tissue and a market to be created for that sale." Close quote. Words are important. The report language and the floor debate created a very clear legislative intent that no one should profit, no one, from the sale of fetal tissue. Yet here, in today's documents and exhibits, we see a business brochure and a website urging, quote, "Partner with us and improve the profitability of your clinic. Improve your bottom line. Be financially profitable." These are quotes. That procurement business offers a payment per tissue to abortion clinics, and it offers to do all the work. That would appear to mean that the abortion clinic has no costs, and it would thus appear to be precisely about profit, as their marketing literature says. Questions of profit and legality matter because we're talking about people. It matters whether or not procurement businesses broke the law. It matters whether or not abortion clinics are lining their pockets through the dismemberment and distribution of children, all while receiving tax dollars. It matters because we're talking about the tiny limbs of little babies that have dignity. They're broken, yet still precious children of actual mothers and fathers. As the committee's exhibits indicate, web pages exist where a customer can click on a drop-down box that lists every organ of a baby for sale. You can click on a brain, a heart, eyes, or a scalp. Then you select your gestation period. Then you proceed to checkout, and you decide the method of shipment. We should pause to linger here. Our humanity should be repulsed. We should all be sad by this. In this committee room and across the country, we will obviously have passionate disagreements and discussions about the legality, the justice, and the social implications of abortion policy. Like many in this room, like a majority of Nebraskans, and like a majority of Americans, I believe that every baby is precious and worthy of legal protection, even at our earliest phases of development. I'm unashamedly pro-life. But I also understand that many others disagree on abortion policy. Our disagreements on abortion will sometimes be heated, but wherever possible, we should be looking for consensus. And here, on this basic reality, we can and should agree. Babies are not the sum of their body parts. Babies are not meant to be bought, and babies are not meant to be sold. Babies are just that. They're babies. They're meant to be welcomed and rejoiced over, held and nurtured. Outside of our congressional responsibilities here, many of us do in fact welcome, hold, and nurture little children. We adopt and we foster and we mentor them. We offer hope, support, and encouragement to their parents. Madam Chairman, your work can and does transcend politics. I appreciate also your concern with children born alive inside abortion clinics and with the treatment that they receive. When I think of all the survivors of abortion, and I think about your investigation into the sale of baby body parts for profit, it makes born again, born alive legislation all the more important. The Born Alive Abortion Survivors Protection Act has already passed the House by a bipartisan vote of 248 to 177, and I've had the privilege of introducing the companion legislation in the Senate, and I invite my Senate colleagues on both sides of the aisle to be working together to pass this bill in our chamber. This law would simply ensure that babies who survive abortions get a fighting chance by requiring medical attention that is equivalent to what would be offered to any other premature baby born at the same stage. No life is disposable. No child deserves to have her life ended cold and alone, struggling for breath outside the womb in an abortion clinic. We Americans frequently cheer for the vulnerable. We fight for the minority. We protect the powerless against the powerful, and baby girls and boys are fighting for their lives. I encourage my colleagues to fight for them and to support Senate 2066, the Born Alive Abortion Survivors Protection Act. Madam Chairman, we look forward to monitoring the progress of your investigation, and thank you for including me in this hearing.
Thank you, Senator Sass. We appreciate your time. We're sorry for our delay, and we know that you have to scoot back across to the Senate for votes, but thank you for your time. At this time, I would like to call forward our second panel. And as they move forward to be seated on the panel, I will move forward with introducing this panel to our audience so that we can move forward expeditiously. Faye Clayton is an attorney with Robinson, Curley, and Clayton. Ms. Clayton practices civil litigation for a wide range of clients, from major corporations to individuals in cases involving fraud, RICO, securities, general commercial matters, contract disputes, officer and director liability, and shareholder and partnership concerns. Mr. Robert Rabin served as Assistant Attorney General for Legislative Affairs with the U.S. Department of Justice, where he drove Attorney General Janet Reno's legislative initiatives and handled the political challenges of congressional oversight of the department. He founded the Rabin Group, a public policy consulting organization, in 2002 and continues to serve as president. He is a graduate of the Wharton School and the New York University Law School. Mr. Brian Lennon served as a federal prosecutor in Michigan and Virginia for 15 years and a trial attorney for the U.S. Department of Justice's Civil Division. As a deputy chief of the Criminal Division for the U.S. Attorney's Office in the Western District of Michigan, Brian supervised the healthcare fraud and computer-related crimes units, among others. He also spent 4.5 years as a judge advocate for the U.S. Marine Corps, handling both civil and criminal matters. Now in private practice with Warner, Norcross, and Judd, he specializes in criminal defense, particularly healthcare fraud and other white-collar and drug offenses, corporate internal investigations, and compliance matters. Mr. Michael Norton served as U.S. Attorney for Colorado from 1988 to 93. He was appointed by President Reagan and reappointed by President George H.W. Bush. Mr. Norton has been practicing law since 1976 and is admitted to the bars in the states of Colorado and Virginia, as well as Washington, D.C. Catherine Glenn Foster is an associate scholar with the Charlotte Lozier Institute, where she authors research papers on science, medicine, and research in the service of human life. She was formerly an attorney with Alliance Defending Freedom and is a graduate of Georgetown University Law Center. Kenneth Sakaya was appointed U.S. Attorney for the Northern District of Florida by President George H.W. Bush and has served as litigation counsel to numerous corporations and officials. Mr. Sakaya has also served as law clerk at the Florida Supreme Court and the U.S. Court of Appeals and as a senior partner in one of Florida's oldest and largest statewide firms. He began his own firm, the Sakaya Law Group, in the Florida State Capitol in 2008. You are aware that the Select Investigative Panel is holding an investigative hearing and that we will take your testimony under oath. Do you have any objection to testifying under oath? Okay. The chair then advises you that under the rules of the House Committee on Energy and Commerce, you are entitled to be advised by counsel. Do you desire to be advised by counsel for today's hearing? Okay. In that case, will you please rise and raise your hand, and I will swear you in. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. You are now under oath and subject to the penalties set forth in Title 18, Section 1001 of the U.S. Code. You will each give a 5-minute summary of your written statement. Ms. Clayton, we will begin the testimony with you, and you are recognized for 5 minutes. Yep, push your microphone
Oh,
on.
there we go. Okay.
There.
Thank you, Madam Chair. I've been a corporate litigator since 1978, and I'm here today despite a family medical situation for 2 reasons. One is that women's reproductive health and medical research are being threatened by these hearings. The second reason is that I have instructive experience to share with this panel on the topic that you're considering here. 16 years ago, a client of mine, Anatomical Gift Foundation, a nonprofit corporation that provided donated tissue to medical researchers in hopes of curing the diseases, including the ones Senator Shaheen mentioned earlier. That nonprofit was falsely accused by Life Dynamics, the anti-abortion group Congresswoman Schakowsky mentioned, accused of selling fetal tissue. These baseless charges were made in a videotape sent by Life Dynamics to Congress, and in that video, the person making the accusations was anonymous. As it happened, an employee of Anatomical Gift Foundation, my client, had gone to work for another company in violation of his contract. AGF hired me to sue. That man's name was Dean Alberti. In Alberti's deposition, which was under oath, like all of us today, but unlike what he said in the videotape that Life Dynamics had sent to Congress, Alberti admitted that he was the person in that video, and he admitted that what he had said in that video was fictional. He testified that he told those lies because Life Dynamics had paid him to, and he said, "I needed the money." He had repeated those falsehoods on TV's 2020, but he knew better than to lie under oath. When I deposed him, where the penalties of perjury, as the chair acknowledged, do arise. Those of you who were here in the year 2000 may recall the humiliation that certain members of the House committee suffered when their star witness, Dean Alberti, went up in flames and admitted that that much-touted video had been fabricated. Those House hearings established that my client had done nothing wrong, that fetal tissue wasn't for sale at all, and that anti-abortion zealots, Life Dynamics, had foisted a false witness on Congress. What was for sale wasn't fetal tissue, it was a phony witness statement, and it had been bought and paid for by anti-abortion extremists. I find it curious, given the not-so-distant history of this strikingly similar scenario, that this panel has not demanded sworn testimony of the accusers, the latest batch of anti-abortion accusers, as you've asked of us, Chair Blackburn. Haven't asked for that, haven't asked them to go under oath, and that seems strange to me, particularly when they come up with such a similar tale about the so-called sale of fetal tissue, which again is a lie. This suggests to me that someone is afraid to put David Daleiden and his star witness Holly O'Donnell under oath because, as we saw with the Dean Alberti fiasco, when penalties of perjury attach, sometimes, instead of fiction, the actual truth comes out. We know Daleiden and his crew doctored videos to the point that the federal judge blocked the release of further tapes because they were fraudulent. Another fact we know about them comes from the Los Angeles Times' examination of Daleiden's unedited videos. They show Daleiden coaching and manipulating the testimony of Holly O'Donnell, whose video interview, by the way, looks more like play acting than any genuine emotion. Without cross-examination of Daleiden and his crew under oath, we have no way of knowing what he offered or said to Ms. O'Donnell when his camera was not running. And in Texas, when Daleiden went before a grand jury convened for the express purpose of prosecuting Planned Parenthood, the grand jury did something very different. It didn't indict Planned Parenthood, it indicted Daleiden for falsehoods. And the Texas grand jury found, of course, that Planned Parenthood had done nothing wrong. For nearly 4 decades, I have been representing corporations and individuals in business litigation. And I have to say, there is no bigger tell about the veracity of an accusation than when the person who's making the accusation will not stand by his or her accusation under oath. As Alberti told the House Committee in the year 2000, quote, "When I was under oath, I told the truth. Anything I said in the video when I was not under oath, that's a different story," close quote. So I have to ask, is this panel looking for the truth or for another story? A real inquiry would start with sworn testimony from Daleiden and O'Donnell, and that would be true even if the doctored videotapes didn't have so much in common with the deceitful tapes that the abortion opponents, including Life Dynamics, staged 16 years ago. This panel's failure to allow cross-examination of Daleiden and his cohorts sends a message loud and clear that those stories would not hold up under penalty of perjury any more than the baseless slurs Dean Alberti made back in the year 2000 when Life Dynamics bought and paid for his testimony. And by the way, you know Crutcher is one of the trainers of Daleiden. It just strikes me as inexcusable that the panel has been using its subpoena power to compel testimony from healthcare providers and medical researchers who have far better things to do with their time, like providing health care, working to cure disease, than Daleiden and his crew. I just ask that until and unless this panel puts Daleiden and O'Donnell under oath and gets down and tries to get to the bottom of what they did, that these proceedings be terminated and our elected officials be allowed to return to doing the people's business. Thank you.
Thank you, Ms. Clayton. Mr. Rabin?
Good morning, Chair Blackburn, Ranking Member Schakowsky, members of the committee. Thank you so much for having me this morning. My name is Robert Rabin. I'm in private practice. Over the years, I've served as counsel to the House Judiciary Committee and was confirmed as Assistant Attorney General for the Office of Legislative Affairs at the Department of Justice. In 1999, as I was watching you this morning and the decorum and kindness with which you obviously run this committee, I was reminded that my then chair, I was Democratic counsel, but the chair of our committee, Henry Hyde, walked across the Capitol to testify for my nomination. And what a wonderful day that was, and how much I miss him and appreciated him. I have taught law, practiced at a large law firm, and clerked after law school. I deeply appreciate the law and this committee's attention to it. For over 20 years, my work has involved the representation of people and organizations before the congressional and executive branch. I give this testimony today as someone who has experienced both sides of advocacy and representation around investigations of all forms. This committee has asked us to opine on the questions of whether the current legislative language adequately prevents profiteering in the sale of fetal tissue and the parameters around what constitutes a sale of profit of fetal tissue. In 2000, in my capacity as Assistant Attorney General for the Office of Legislative Affairs at the Department of Justice, I was called upon to respond to almost identical concerns expressed by members of the Congress regarding the alleged transfer of fetal tissue for profit. On March 9th, 2000, I communicated with Congress by signed letter a willingness to investigate and learn further about credible claims and allegations. While I don't have specific recollection of further oral conversations within the department subsequent to that written communication, I know from the public record that in July of 2000, acting Kansas U.S. Attorney Jim Flory decided, after a thorough review of the issues involved, that there were no violations of federal statutes, thereby announcing the closure of a thorough investigation into related facts. That is a matter of public record. I also recalled yesterday a second investigation from the Colorado U.S. Attorney and FBI that was similarly closed. We are today witnessing virtually identical allegations. While I am unaware as to whether DOJ or the FBI presently have ongoing inquiries into the factual allegations, it is significant to note that 12 states have affirmatively looked into related matters and declined to pursue any charge. Additional 8 states have affirmatively declined to even investigate. Given the importance that some people have about deferring to the states, I'd like to just read into the record the 12 states that have affirmatively said they have investigated and decided not to pursue charges around related allegations: Florida, Georgia, Indiana, Kansas, Massachusetts, Michigan, Missouri, Ohio, Pennsylvania, South Dakota, Texas, and Washington. Innumerable reasons exist as to why federal law enforcement has little record of indictment under the existing language, which may include the dearth of actual profiteering in fact, the deference to state law enforcement authorities, which are certainly capable of determining the same predicate, past failed attempts to establish wrongdoing, or, paramount in this area, a lack of credibility of those presenting facts to the law enforcement officials. Of the ultimate question on which this committee is presently engaged, whether or not the existing statute merits either change or more rigorous enforcement, I believe that the statute is sound and fully addresses its intended aims, as important today as it was when it passed with overwhelming bipartisan majorities in 1993. The statute, a considered bipartisan judgment of Congress, was meant to address profiteering from the sale of fetal tissue. There is no evidence of an outbreak of such behavior in this nation. Further, I am confident that any acts of intentional misbehavior would be investigated and punished by law enforcement, both federal and state. Thank you for having me.
Thank you, Mr. Rabin. Mr. Lennon, you're recognized for 5 minutes.
Chairman Blackburn, Ranking Member Schakowsky, and distinguished members of this panel, thank you for the opportunity to speak to you today about the pricing of fetal tissue. I'm currently a partner at the law firm of Warner, Norcross & Judd in Grand Rapids, Michigan, but for 13 years before entering private practice, I was an assistant U.S. attorney in the Western District of Michigan. I'm not a medical ethicist or a theologian. I do not represent any advocacy group on either side of the life versus reproductive rights debate, and I'm not here to advocate for any change in federal legislation. But as a former federal prosecutor and now criminal defense counsel, I hope to provide some value to this panel through objective legal analysis of the exhibits to determine whether the abortion clinics and/or the procurement business identified in the exhibits violated the statute. Based on my review of the exhibits, and I looked at this as if an agent had showed up at my office on any working day with these exhibits and asked me to examine them. But based on that review, I believe a competent and ethical federal prosecutor could establish probable cause that both the abortion clinics and the procurement businesses violated the statute, aided and abetted one another in violating the statute, and likely conspired together to violate the statute. In fact, for 5 of the 6 elements of the substantive offense, in my opinion, there is proof beyond a reasonable doubt. The only element where investigation is needed, and that would include, I believe, forensic accounting and analysis thereof, is whether the payments made by the research institutions that ultimately received the human tissue to the procurement businesses were valuable consideration or, alternatively, reasonable payments associated with the specific allowable services in the statute. With respect to the abortion clinics, in my opinion, the proofs more clearly establish that the compensation they receive from the procurement business, a price per tissue payment, is indeed valuable consideration, and as none of the identified services excluded from the definition were provided by the clinics. Now, prosecutors and jurors clearly prefer defined and established elements of the offense. 5 of the 6 elements of that offense are both clearly defined and established through the exhibits. As for the final element, valuable consideration, that element and those proofs are admittedly more nuanced. The statute itself defines valuable consideration by describing what it is not. It does not include reasonable payments associated with the transportation, implantation, processing, preservation, quality control, or storage of human fetal tissue. If valuable consideration is payment for something other than this exhausted list of delineated services, this element is also established. As for the abortion clinics, the marketing materials that I have reviewed clearly state that there's a financial profit from this partnership. Several of the exhibits indicate the procurement business pays for per the tissue, not a reasonable payment for the listed services. Therefore, the exhibits indicate, in my opinion, that these services provided by the procurement business through their embedded technicians and not the abortion clinics, therefore, that these payments appear to be valuable consideration. Indeed, they could be profits. As for the procurement business, it's my opinion that a much deeper analysis of the company's financials is necessary in order to establish the valuable consideration element beyond a reasonable doubt. Because the businesses do in fact incur costs associated with these delineated services, a forensic accounting would be essential to breaking down the company's financials. Just looking at the growth and looking at their revenue doesn't tell you whether they're profiting, and if they're profiting, in my opinion, they violated the law. I think there's some other theories here, although, that I think a prosecutor would pursue that may be more important in looking at the potential criminality of the businesses, the procurement businesses, and those are aiding and abetting and conspiracy. Based on my limited review of the exhibits reviewed and the strength of the substantive case against the abortion clinic, pursuing an aiding and abetting or conspiracy count against the procurement business rather than the substantive count may be a stronger theory of culpability. As I conclude, I would just say that I believe federal prosecutors take pride in protecting the most vulnerable among us. The ones I proudly served with in the Western District of Michigan did not shy away from the tough cases, and they put their personal politics aside when asked to evaluate cases for prosecution. Evidence or the lack thereof, not politics, should determine whether a U.S. attorney impanels a grand jury to investigate abortion clinics and human fetal businesses in their district. Again, I thank you, Chairman Blackburn and Ranking Member Schakowsky, and the members for allowing me to testify today, and I welcome your questions.
Thank you, Mr. Lennon. Mr. Norton, you're recognized for 5 minutes.
Thank you, Madam Chair, and Ranking Member Schakowsky and esteemed members of the committee. My name is Michael J. Norton. I'm an attorney in the private practice of law in Denver, Colorado. I've had the privilege of serving as United States Attorney for the State and District of Colorado, first appointed by President Ronald Reagan and then reappointed by first President Bush. Mr. Gett, nice to see you again. I have a written statement which I respectfully request be incorporated in the record, and I simply just want to summarize my comments and my remarks in the time that's available. First of all, I would say to the committee that this is not about women's health. It is not about abortion, how one stands on the issue of abortion. It's whether or not there is probable cause to believe that crimes have been committed, and if so, what to do about that. To do nothing about the potential of the commission of criminal crimes is indeed flouting the criminal justice system of this nation, and I think preferring those who are in well-connected places over those who are not. So I suggest to you at the outset, Madam Chair and members of this committee, that what this committee is about is highly important and very critical to the criminal justice system and to the sanctity of that system in the United States of America. It's really not about the issue of abortion, because potential profiteering and trafficking in aborted fetal tissue is of grave concern, not only on the federal level, but also in many states, including my own state of Colorado, which has adopted a law similar to the federal law that is being looked at by this committee today. There are many, many people, therefore, concerned that not only this federal statute, but also the state statutes at issue have been violated and are being flouted by the abortion industry. In 2015, it was revealed by one of these undercover videos that Denver's Planned Parenthood of the Rocky Mountains was indeed making a profit by harvesting and trafficking the hearts, the brains, the lungs, the eyes, the livers, and other body parts of babies whose lives Planned Parenthood had ended by abortion. These gruesome revelations came from a series of videos released by this Center for Medical Progress that the committee has talked about. And it was clear from the videos that Planned Parenthood had been actively engaged in harvesting and trafficking for profit body parts of babies whose lives Planned Parenthood had ended. Those videos have not created a general queasiness about surgery and blood. No matter how one stands on the issue of abortion, no one who has viewed these videos can come away thinking that Planned Parenthood's harvesting and selling of these baby body parts is consistent with our values or consistent with the law. If wrongdoing has occurred, and I concur with the assessment Mr. Lennon has made of the facts and the circumstances, as to the commission of crimes in this case. And I would add that it appears to me, quite frankly, that criminal violations of the Health Insurance Portability Act, HIPAA, have also been committed by the embedding of the procurement business technician in the abortion facility itself, and the review by that technician of privileged medical records of patients in order to determine which body parts that technician wants to have harvested and sold to him has also been committed. There are some facts that need to be determined, and a competent criminal investigation could determine those facts. But to do nothing is simply wrong, Madam Chair and members of this committee, and I thank the committee for its courage in moving into this area, investigating this area. I urge it to complete its investigation and to refer this matter to the U.S. Department of Justice for appropriate action, which I pray and hope is taken. Thank you, Madam Chair.
Thank you, Mr. Norton. Ms. Foster, you're recognized for 5 minutes.
Thank you. Thank you. Ms. Chairman, Ms. Schakowsky, distinguished members of this panel. I am privileged to present this testimony concerning the pricing of human fetal tissue. My views are consistent with those of the Charlotte Lozier Institute, where I am Associate Scholar, which is dedicated to advancing science, medicine, and research in the service of human life, and to promoting a culture and polity of life. My views are similarly consistent with those of Sound Legal, a law firm and legal organization advocating for the universal right to life. As an attorney, I have dedicated my career to advocating for the right of every innocent human being to be protected. And so I am troubled by those in the abortion and tissue procurement industry who scheme to trade in baby body parts for their own financial enrichment. The public learned of these back alley transactions last year when undercover videos of the organ business brokers surfaced online. Indeed, the trade in fetal body parts is a business. As demonstrated by the evidence presented by this panel, clinics and procurement companies have been getting away with charging far more than the allowed costs for harvesting, transporting, and warehousing body parts as they wait for customers. In doing so, they have violated both the intent and the letter of Section 289G2, which bars, among other things, the transfer of human fetal tissue for valuable consideration. The statute's definition of valuable consideration is straightforward. If payment is not reasonable or not associated with the transplantation, implantation, processing, preservation, quality control, or storage of human fetal tissue, it is not permitted. We can all agree on this statute. It passed with bipartisan support in a Democratic Congress and was signed into law by President Clinton. Representative Waxman at the time called the fetal corpse market abhorrent. And yet, the panel's evidence reveals that abortion clinics are being promised a profit and are paid even when they have no apparent costs to be reimbursed, and further multiplying a clinic's windfall via savings on disposal services. Tissue procurement companies are likewise paid exorbitantly by their customers. This market in baby organs and tissues demonstrates a flagrant and repeated disregard for the rule of law. It was no surprise when America's biggest abortion business, facing public and prosecutorial exposure, relented and agreed to end its long-standing practice of receiving direct payments for baby body parts. And yet, in my years of work in this field, and in the 23 years that Section 289G2 has been law, I am unaware of a single instance in which it has been enforced. This panel is right to shine a light on big abortions' back alleys. For perhaps we forget that this law was meant to protect the ethical imperative that recognizes the dignity in every human life. In the face of clinical sanitized language, we may become desensitized. In the abortion clinic, a human baby is called tissue or a fetus. A head is a calvarium or cow. The technician who counts body parts is a products of conception or POC worker. And by converting human lives into a bulk commodity, public discussion has been stifled. But we are in fact talking about real and unique human beings whose lives were tragically snuffed out. We are talking about affording them the minimal dignity that comes with not having their remains further picked through to be bought and sold like chattel. I know that the abortion industry and its allies are waging a campaign against any effort at transparency or accountability. It is what we can expect from a big business with an emphasis on maximizing profits and a lot of money to lose. And so, big abortion is fighting back with all its financial and political might, investing its political and monetary stockpile to buy public sanction, and weighing its thumb down on the scales of justice with high-profile PR firms, pocket politicians, and spellbound media. With these allies, until now, the abortion industry has succeeded in shouting down the voices acknowledging the public evidence of guilt and crying out for justice. But no more. We, the people, are not afraid of confronting the truth, and we encourage this panel and those in law enforcement to pursue it. Common sense and common decency demand enforcement of Section 289 G2. Thank you.
Thank you, Ms. Foster. Mr. Sakaya, you are recognized for 5 minutes.
Thank you, Madam Chairman, and the members of this committee. I was privileged and honored to serve as the United States Attorney for the Northern District of Florida, and before that was an Assistant U.S. Attorney for 10 years. Much of my expertise that I could lend to the committee would be in, of course, the area of determining whether a grand jury should be impaneled, whether a case should proceed, whether investigation should be pursued. And I've heard it said today that this is a committee that has disdain for the truth, that this is not a fact-based inquiry. And when I looked at the exhibits that were submitted, but also, of course, when I looked at the videos that were presented, it strikes me as odd that there would not be an aggressive and meaningful investigation into the allegation that indeed human baby parts are being sold for profit. Article 2, Section 3 of our United States Constitution, in fact, requires of the executive branch that it faithfully execute the laws of the country. By not faithfully executing those laws, you are, in fact, taking specific affirmative action to defy what is required by the Constitution. And in this situation, it is beyond my assessment and belief that when you have a procurement industry that is actually marketing to the abortion clinics that they can procure or work to gain more profits by this method, and when they are seeding their own employees in the clinic to do those jobs that would indeed cost and would indeed be the services that would comprise the legitimate cost or payment for those services, then the question clearly arises, have these clinics profited from this process? It's a very simple, basic issue. And so we're not saying, as a prosecutor, when someone comes in the door with this evidence, oh, this is absolutely, positively a fact. We're saying, no, this justifies a full and complete and a thorough investigation. And I think it's, there does seem to be a pattern when, oh, this can't possibly have any basis because, let's see, 16 years ago, someone lied. So we can't take this. This is the same sort of thing that's happened before. And we should also stop the prosecution of all murders because there have been cases where persons have lied and people have been wrongly convicted. And the whole argument is nonsense. And in fact, this whole notion that oh, let's fall all over ourselves to insist that, oh, we're being, this is nothing but an effort to attack the reproductive rights of our citizens. when it is in fact an effort to enforce the law, which is required of our Constitution. Thank you.
Thank you, Mr. Sakaya. At this time, we will begin the
Madam Chair,
questioning
Madam
on
Chair.
our side. Yes, the gentleman is
Parliamentary inquiry,
recognized.
please.
Parliamentary inquiry. State your inquiry.
Yeah, Madam Chair, the witnesses appear to have relied heavily on the premise from your staff that clinics incur no cost related to fetal tissue donation. That premise is captured in Exhibit G, which you previously had up on the screen. Could you put that up on the screen for a moment again, please, while I complete the parliamentary inquiry? Exhibit G.
Let's bring up Exhibit G, and please state the inquiry.
Is that Exhibit G? That's not Exhibit G. That's it. Thank you. Madam Chair, this chart says that the clinic has, quote, no costs, so the payments are pure profit for the clinic. This is contradicted by Exhibits C6, C9, and C17, which show that some clinics obtain consent, draw blood, fill out paperwork, among other things related to fetal tissue donation. These are all costs that the Government Accountability Office recognized 16 years ago as reimbursable, quote, direct costs, unquote. Madam Chair, can you explain how this document, Exhibit G, was created and its factual foundation, including the discrepancy between what this staff-created chart asserts, namely that there are no costs, and information on other documents in your packet, the Exhibits C6, C9, and C17, which detail such costs?
I thank the gentleman for the inquiry. We discussed this previously before you arrived at the hearing, and all of the documents today come from the investigative work that took place by submissions that came to us, whistleblower information. The charts for discussion, of which G is one, were compiled from that work by our staff, and at this time we begin our
Madam Chair,
questioning, and I turn to Mr. Pitts.
Further parliamentary inquiry, and I don't
State
believe...
the inquiry.
Thank you. I don't believe this was discussed while I was at the Judiciary Committee. How can you explain the discrepancy between the information on Exhibit G, namely that no costs were incurred, and the information on Exhibits C6, C9, and C17, which list some of those costs? That didn't happen.
There is no discrepancy, and I thank the gentleman for the inquiry. At
I
this
will
time,
show you
we
the
began
discrepancy.
our hearing with Mr. Pitts.
Further parliamentary discrepancy. Of course there's a
Do
discrepancy.
you have a motion?
No, I have a parliamentary inquiry, and I will,
Okay.
which is being sidestepped and not answered. This Exhibit G says abortion clinic, explanation, the abortion clinic has no costs, so the payments from the PB, the procurement business, to the AC, the abortion clinic, are pure profit. All costs are borne by the PB or the customer. Exhibit C9 says it's an exhibit of clinic procedures and policies, and it says you must inform, you, the employee, must inform the assistant manager and HSSs when you have completed your work. This will ensure that they do not continue to consent and draw unnecessary blood samples. The interaction of...
If the gentleman will yield, you're citing a procurement business procedure. So one is the clinic, one is the procurement business. I thank the gentleman for the inquiry.
The procurement business has to tell the clinic staff, which has to be satisfied, and that takes time and is a direct cost.
At this,
So that they have to tell the abortion clinic that they're done, so that the abortion clinic does not continue to take more samples, et cetera, which is a direct cost for the clinic, not the procurement business. So that is a direct contradiction.
the documents are separate. It is not a direct contradiction, and the documents are separate. One is relates to abortion
Then what
clinic,
is
the other to the
if this is
procurement
not-
business.
If this is not a direct contradiction, what is the methodology to determine that there are no costs for the abortion clinic as asserted in Exhibit G, which apparently has no basis?
It's all based on the investigatory work, and I thank you for the parliamentary
Well,
inquiry. At
based
this
on the
time, we're going to
investigatory
Mr.
work, we see the
Pitts.
Investigatory, and further parliamentary
We have,
inquiry, further and final, I hope, parliamentary inquiry. Can you explain how using a chart that draws conclusions that have no objective basis in fact other than your statement that somebody investigated, does not violate House rules prohibiting conduct that does not reflect creditably or may discredit or dishonor the House in this panel, Rule 11, Clause 4, and Rule 23, Clause 1. First, what I'm hearing is that staff people somehow derive this information. We're not told how. or
Mr.
from
Nadler,
where, and
you know, this is
information
not a
should be-
parliamentary
Oh, yes, it
inquiry.
is.
Basically,
How does
you're
this
trying
not-
to debate the documents, and we need to move on with our questions.
does
And
this
I'm
not
turning to
violate
Mr.
the-
Pitts. Mr. Pitts, you're recognized for 5 minutes for question.
Thank you, Madam Chair, for calling this important hearing on the pricing of fetal tissue. This issue has caused me considerable concern because one of the underpinnings and safeguards of the statute that allowed for the donation of fetal tissue for transplantation and research was that this tissue would not be sold. The author of the statute, Representative Waxman, stated during the floor debate in 1993, and I quote, "It would be abhorrent to allow for the sale of fetal tissue and a market to be created for that sale," end quote. And yet, this is what is happening, as one of the witnesses said, in the back alleys today. As seen on Exhibit B2 and B3, the procurement business markets itself on its brochure as a way for clinics to make additional income by allowing the procurement business, procurement technicians, to take fetal tissues and organs from aborted babies immediately after the abortion was completed, using the words financially profitable, fiscally rewards, financial benefit on its brochure. The Select Panel investigation reveals that every conceivable harvesting task is performed by the technician employed by the procurement business. And so procurement businesses, essentially the middleman, are paying fees to abortion clinics, but the abortion clinics are incurring no cost. Exhibit D shows payments from the procurement business to abortion clinics for aborted babies and baby blood. Exhibit D1. The abortion clinic charged the middleman with a bill for $11,365 in August of 2010 for baby parts and blood that the middleman's technicians harvested. Another invoice in January, February of 2011 charged $9,060 for harvested baby parts and blood. The middleman even makes it easy for the researcher to purchase baby body parts. Exhibit C3, the procurement business order form, or the drop-down menu for baby organs, shows just how easy this is. First, it asks on the left side, quote, "What type of tissue would you like to order?" And I suppose you could respond. Anyone could respond to this. I would like to order brain. And then it says number of specimens. Well, 6, let's say, baby brains. Gestational range, start and end. Well, that'd be 16 to 18 weeks. And then here's another question. Add another tissue type? You could say yes. Another tissue type listed, female reproductive system and ovaries. You could say I take 5 of those at 15 weeks. You could add, send 5 baby tongues. Shipping or options. You could respond, yes, I want it rush ordered. So for crying out loud, this is the Amazon.com of baby body parts. There is a market for baby body parts, and you get what you pay for. This is absolutely repulsive. And we must not forget it, as was testified here, each one of these, little baby brains or tongues represent a baby. How can anyone defend this practice? All this shows that in both intent and in practice, these organizations were making money well above the actual costs. So going back to Exhibit B2 and B3, the company brochure, the website show intent, their publicity, marketing materials. My question for the former prosecutors for DOJ, we'll start with Mr. Sukiya, Mr. Norton. What communications or information would you seek to learn whether the intent of the procurement business and the abortion clinic was to profit from selling baby body parts? Mr. Sukiya, let's start with you.
Congressman Pitts.
Put on your mic.
Yes, sir. I had pressed the button and then it went off. Some of that evidence is already in this record. I've heard, again, everyone quickly rushing to insist that these videotapes are just deceptively prepared. In other words, do what we're extremely deft at doing, this industry, which is deflecting, and everyone else is at fault. Let's shift the focus so everyone's focused on, hey, what these videos did and what this person said in the video, how he prepared the videos. But those videos were posted. All of those videos were posted. And there are some things that when people say them on tape, it doesn't matter what they didn't say or did say elsewhere. If someone is saying that would be good and we're talking about profiting from this and they're talking about that, that's corroborative evidence. It corroborates the evidence that you were identifying, Mr. Congressman, which is very strong evidence when someone is actually marketing for it. So
Let's answer quickly. Time has expired.
I would also want to know what communications occurred between other communications, email and so forth, back and forth between those people. We would seek those items as well, and of course the accounting records. So, thank you.
Yield back.
Gentleman yields back. Ms. Schakowsky is recognized for 5 minutes.
No, unfortunately, we have, the majority has refused to even bring in the one party that actually could answer these questions, and that is STEM Express. And I want to say, Mr. Sukiya and Mr. Norton, as lawyers, the fact that you keep referring back to these completely discredited by 3 congressional panels, by 12 states that looked into this, by a grand jury that ended up, you talk about the Center for Medical Progress, Mr. Sukiya, which is it, Sukiya?
Sukiya, thank you.
I'm sorry. And yet, Mr. DeLayden and his partner were actually indicted as a consequence. So, you know, that's a comment. It is not a question. It is a fact that has been looked into. The other thing is, before I want to ask Ms. Clayton a question, but I also want to go back to a letter and numbers of documents presented by STEM Express that would completely discredit the exhibits that have been mentioned. And I want to just, as far as B2, the majority's use of this brochure is misleading at best. It was used by STEM Express with hospitals and clinics involved in a broad spectrum of work that the company supports related to adult blood, adult tissue, biopsies, etc., not fetal tissue donation. Exhibit B3, the STEM Express website screenshot, makes absolutely no reference to fetal tissue. In fact, it pertains to the overwhelming majority of STEM Express's work with adult blood and tissue that has nothing to do with fetal tissue, which accounted for less than 1% of the company's revenue in 2014 before losses. They have repeatedly offered to come in and provide exactly the specific information that is raised in these exhibits, and that has been turned down. I think it is shameful for an investigation that seeks to get supposedly to the truth. Now, I want to ask Ms. Clayton a question, and I think that this parallel is worth examining because the facts are the same. Discredited video which led to an investigation that found no guilt. So I want to skip part of this, but ask, there were accusations made against your client that impacted him, the client that was found to have done nothing wrong. And I wonder how it affected his business reputation, his own safety, and that of his family.
Yes, Congressman Schakowsky, it was a company, Anatomical Gift Foundation, and it was threatened by terrorists on the anti-choice side, including the Army of God. That's the group that shot Dr. Tiller, not the time he was murdered, but the time he was shot before his murder. Army of God is one of the most violent, outrageous anti-choice groups around. And AGF, my client, received threats of that as soon as these outrageously fallacious videotapes were sent to Congress and got circulated when they were on 2020. And everybody believed they were true. Oh, it must be true. We saw it on a videotape, not under oath. I would just comment that anyone who wants to look at a defense of any of this, first thing you do, get Mr. DeLayden under oath. See what he says when the penalty of perjury would attach. Because when Mr. Alberti was under oath in the deposition that I took, he suddenly started telling the truth. And what he told was that everything else was a lie. Meanwhile, these threats endanger the life and safety of people at clinics all over the country, as in Colorado. A crazy Mr. Deere murdered 3 people because he thought it was true about these tapes, the sale of baby body parts, even though 12 states, the Texas grand jury, have found that's completely fallacious.
I just want to say, your client provided a letter sent by this anti-abortion group to your client's wife. In that letter, the group referenced baby parts, that's a quote, and warned her that it was, quote, watching you and your husband, unquote, and that this is, quote, this is only the beginning. And I seek to unanimous consent to enter this March 9th, 2000 letter.
Ordered.
And I believe that there is a connection between the murders at the clinic in Colorado Springs following these deceptive videos where the murderer said, no more baby body parts. And the repeat of that language and the repeat of the false accusations and the collection of names, a database of names of people involved in research and in clinics is dangerous. It is dangerous. We should not be doing that in the United States of America, and I yield back.
Gentlelady's time has expired. I yield to Ms. Black for 5 minutes.
Thank you, Madam Chair, and I thank the panel for being here today. I do want to focus on Exhibit G, on who bears the responsibility for the tissue procurement chart. As a nurse, I am well aware of how important it is to follow procedures, especially in performing your duties when you're caring for a patient that has trusted you as a care provider for their medical treatment. So let's walk through a day in the life of a procurement tech. And if you will please turn to Exhibit C for this question. In Exhibit C4, you will see that the tech gets an email gets an email like the one that's on C4, and she reads the order for certain baby body parts, including the gestation period, and knows what she needs to harvest for that day. And I want to reference second from the bottom line. It says that she will need a brain 16 to 18 weeks, and complete, but can be in pieces. So she has a very specific tissue that she is looking for. Now, if we can turn to C9, Exhibit C9. And then she informs the abortion clinic staff of what she will be procuring on that day. And we actually see there on the first line where she communicates with the assistant manager, it says, upon arrival, inform the staff clearly of what you are procuring for the day. So let's follow on then with Exhibit C5. The procurement tech then reviews the medical files, which is another subject of whether this is a HIPAA violation, whether she has the rights to be looking at those files of the patients to learn their names and the gestation time of their baby. And she records this in a gestation tracking log, essentially matching the patient with her needs. Not the patient's needs, but with her needs of what she's been given as her job for the day. Let's next turn to exhibit number 8. Next, the procurement office, the procurement tech approaches the patient waiting for this abortion, and many times this is a young woman who is afraid, not always certain about what she's doing, and needs advice and counseling. But that's not what we see her getting here. She doesn't have, this tech doesn't have much time, and she must match her orders with the patient who are at the right gestation time. So she asks for the patient by name, and then she consents with them to donate by saying that her baby tissue is about curing for potential diseases such as diabetes, Parkinson's, and heart disease. And I want to also reference the second paragraph here, where she actually says that the law in the state of California, which is where this is being done, requires that the tissue from your procedure be incinerated. If you go and look at the law there, she's leaving one thing out. She could offer to this mother to actually bury this baby. But that's left out. She has given, I think, decisions that are very difficult. Either you're going to incinerate this baby or you're going to give this baby up for research. I think that you certainly should be counseling and giving all options to this young woman who is in a very difficult situation in making that decision. Now let's turn to exhibits C12. And then after that, C13, because after the abortion, the procurement tech collects the tissues and procures the baby body parts needed. She carries all of her supplies with her. And you'll see here in this particular exhibit that she has a very detailed instructions about what she is putting these body parts into. So this is not coming from the abortion clinic. This is actually coming from the procurement agency that she is working for. And then the tissue tech then arranges for the delivery. We can see that that is by FedEx. It's clear on the first exhibit and also on this one about who is paying for the delivery of this, not only the test tubes and so on that she will be using to put the specimen in. So let's go back again to Exhibit G, where we see here in Exhibit G a blank on where the expenses are for the abortion clinic, because as I walked you through her day, there's nothing to indicate that the abortion clinic has incurred any expenses. So let me ask you, Mr. Lemon, if you were to walk through this, how does this comprehensiveness of the tissue tech's work inform your thinking about whether the abortion clinic is profiting from the sale of baby body parts?
Thank you. I did consider that in my analysis here. And so the question that was raised earlier in the parliamentary question by the representative from New York was that, that maybe there was a conversation. And in this case, there was a conversation. But then the payment should be maybe for that conversation in the processing, because that's the only thing I see that where the abortion clinic would have any cost incurred for that conversation, not a per tissue, price per tissue payment. That informs me that we're talking about the sale of a part and not some reasonable cost. The other, I think, attack that a defense counsel, which I now do, would say is, well, they're also involved in the processing because you know, the client, the patient is there. But the abortion itself is not the processing of the tissue. It's the creation of the tissue through the destruction of a human life. So I think there's really no argument I saw from any of this that the abortion clinic had any other cost. They were getting a per tissue payment.
Thank you, Mr. Lemon. I yield back.
Gentlelady's time has expired. Ms. DeGette, you're recognized for 5 minutes.
Thank you so much, Madam Chair. As a former litigator myself, there's nothing I like better than a panel of lawyers. I have a series of questions that I would prefer a yes or no answer, if I may. The first question I have for the panel is, we received a packet of documents from the majority. I believe I've seen you all referring to it during this hearing in a binder. So my first question is, have you seen these documents before today's hearing, Ms. Clayton, yes or no?
Yes.
Mr.
Yes.
Rebin?
Yes.
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 Thank you. And did you personally author any of these documents, Ms. Clayton?
No.
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 Have you spoken with anyone who authored any of the documents about the information that the documents contain?
Not to my knowledge.
No.
Not to my knowledge.
Not to my knowledge.
Not to my knowledge.
Maybe, but I don't know.
Who have you spoken with then?
Just the folks who
Do you
contacted.
have names?
March Bell, and I think that might be it. I was
And that's from
contacted.
majority staff?
Yes.
Thank you. Now, for the documents that are listed in the index that accompanied the packet as coming from a, quote, procurement business, have you spoken with that procurement business about the documents, Ms. Clayton?
No.
No.
Ruben?
No.
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 No, and that's
thank
why
you.
there needs to be
Now,
an investigation.
Excuse me. Now, do you have any firsthand knowledge of how the procurement business in question created the documents used in today's exhibits, Ms. Clayton?
Absolutely not.
No.
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 And for the documents that are listed as staff created, for example, exhibits B4 and B5, did the Republican staff discuss those documents with you, Ms. Clayton?
No.
No.
Could you remind me what exhibits you're talking
Well, the exhibits like the charts that were clearly staff created?
No.
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 I think we did discuss that.
You
I
did
think the
discuss
staff-
that
I
with
think the
majority
staff
staff.
member indicated
Did they
that those
tell you
were-
the documents, sir, that formed the foundation of those?
No, the nature of.
Thank you very
their-
much.
well,
Now, my last question, do you have any firsthand knowledge of what documents and facts the majority staff relied upon in these staff-created documents? Ms. Clayton?
Absolutely no idea.
No.
No.
Yes.
What, okay, and how do you know that if you didn't talk to the staff, Mr.
The exhibits that were provided to me obviously support the
Well, take a look,
summary
Mr.
of the
Norton, at
documents
exhibit
that you have
B4. No,
identified,
I'm talking
Mr.
about the
Gett.
staff.
Well, I'm just trying to answer your question.
Mr. Norton, I'm talking about the staff-created documents like the charts. Did they tell you what data they used in creating the staff-created documents?
That's not what you asked, but the
Yes,
answer
it
to that is
what I
no.
asked. Thank you. Ms. Foster?
No.
No.
Thank you. Now, Mr. Rabin, I want to ask you a couple questions. Given that no witness on the panel has firsthand knowledge of how these exhibits were created or the underlying facts captured in any of them, do you think it's appropriate for the witnesses to speculate about possible criminal misconduct based on those documents?
I think calling it speculation is entirely accurate. It would be pure speculation. It wouldn't be probative.
Now, you heard in his testimony, you heard Mr. Lennon testify that not based on his experience as a prosecutor, that he believed that these documents in and of themselves not only established probable cause, but proof beyond a reasonable doubt. What is your opinion of that analysis?
I'd be a little frightened if that were the regime
Why?
in which we live.
Why?
Well, several reasons. One, the context in which all of these facts come, and I don't have to go back to 2000, although I do think that is illustrative. Just in the last,
If you can just be brief, I only have 5 minutes.
there's been a volume of inaccurate and deceptive information thrown at committees and the media about this issue. If I were an investigator or a prosecutor looking at it, I'd be extremely skeptical and I'd want to know more before I proceeded.
And wouldn't you want to bring in the people that actually created
clearly.
those documents and put
Clearly.
them under oath?
Yes.
Thank you. Now, Madam Chair, the reason why I'm kind of stuck on this is because if people are selling fetal tissue in violation of the law, we need to get to the bottom of it. We need to find it out. But we can't just have some witch hunt based on some things that were taken off of screenshots and of documents and charts created by staff. And I will tell you, even though 12 states, including my home state of Colorado, by Attorney General Cynthia Kaufman, who is a Republican, who investigated these claims Mr. Norton was talking about against Planned Parenthood of the Rocky Mountains and found no cause of action to investigate, even though 12 states have investigated and found there was nothing. If you want to send it to the Department of Justice for investigation, I'll guarantee you they won't make up little charts with their staffs. They will get to the bottom of it with original documents, and I suggest that's what you should do if you think there's a criminal violation. I yield back.
That is not correct
Gentlelady
about Colorado
yells.
Attorney General Kaufman, Mr. Gett.
The gentlelady yells back. Her time has expired. Dr. Bouchon, you're recognized for 5
Thank you. Mr. Norton, you want to expand on that about the Attorney General?
Yes, Attorney General Kaufman has not investigated the allegations of Rocky Mountain Planned Parenthood or other Planned Parenthood facilities around the country in trafficking in baby parts of bodies. She has taken the position she has no authority to investigate the matter whatsoever,
Thank you.
unless asked by the governor to do so,
Well, will
which the
the
governor,
gentleman
as a
yield?
supporter of
I will
Planned
not
Parenthood,
yield.
has
Well,
not
then
done.
I guess we won't get to the truth of,
Thank you.
of it.
A couple of things. First of all, you know, the indictment in Texas was for using a fake ID, and the dad of a couple of college students, I can tell you, you know, half the college campuses would be indicted over that. Also, it was stated that researchers are losing money on this fetal tissue. If they're losing money, how are they losing money if there's not a financial transaction? The other thing is, I agree that past investigations are completely irrelevant to today's discussion. You know, if that was the case, we would never investigate anything. And the other thing is, the person in Colorado who tragically murdered some people had very severe mental illness, and that was what was impacted that situation, which is tragic. During the time of the 1993 NIH Revitalization Act, everyone had high hopes about fetal tissue transplantation. Just so you know, I was a doctor before I came to Congress. And unfortunately, that didn't work out. And so in reference to this particular procurement agency, which has been mentioned multiple times by the minority, this whole section of the Act was passed to reverse the ban on fetal tissue transplantation. The statute, which applies to all fetal tissue, allows reasonable payments associated with transportation, implantation, processing, preservation, quality control, or storage of human fetal tissue. I know a little bit about this because I was a doctor, and it appears to me that all of these are upstream activities from the abortion clinic in reference to this particular full-service procurement agency. So the question is I'll start with Mr. Lemon. Assuming that is correct under this particular procurement agency we're discussing today, do you see any language in the statute that forms the basis to reimburse the abortion clinic for any costs at all?
I don't, the statute itself doesn't delineate between the two. But I would want to quickly respond to Mr. Rabin. My written testimony submitted makes clear that there were assumptions made, that all this evidence is admissible in court, and that an ethical prosecutor would also have storytellers, either credible insiders or people who are compelled to testify to support this. So my analysis, and the question I think was unfair, my written testimony points out that this evidence needs to be corroborated.
Understood.
But I do think that if the abortion clinic was able to show that there were reasonable costs that were delineated there, and I've seen no evidence of that, then that would be complying with the statute. But I didn't see that in any of the exhibits I was asked to review, and that's the basis of my opinion.
Mr. Norton.
Yes, I would agree with that. I think that there are a fair number. First of all, let me say that in our system of criminal justice, each and every individual is presumed innocent unless and until proven guilty beyond a reasonable doubt. Even those clients Mr. Gett would bring to my office when I was United States Attorney, they would be presumed to be innocent as well from the get-go.
Agreed.
And so that would be the case here. And so there are a number of unanswered issues, I think, that a competent investigation could and should pursue. For example, how much does the abortion clinic receive for an abortion from a client? And what's the source of that? Is it from the patient, from insurers, from Medicaid, from other sources? What, if any, of the services that are provided to the abortion client, that is the woman upon whom the abortion is committed, are unbundled and billed to insurers, including Medicaid? What is the actual cost of the abortion? What are the amounts over and above that cost, and where do they go, and how are they accounted for? In other words, what's happening to those profits? How does the abortion clinic notify the procurement business or procurement business technician of the fact of abortions? It appears from the materials we've provided that the procurement business technician is actually embedded in the abortion clinic and is given access to confidential medical records before the patient even shows up on the scene, so that technician can select what organs the company seems to want at that point in time.
I'm running out of time, so I'm going to have to, Mr. Sakai, you wanted to comment a little on something earlier real quickly.
Well, thank you very much. The federal provision is a federal provision. So all the talk about, well, states having looked at this.
By the way, the states that looked at it, the services in question here weren't provided in the first place. And I'll speak for Indiana, so obviously nothing was done wrong because that wasn't even part of the equation.
So there are different jurisdictions, and from the federal standpoint, from the standpoint of a federal prosecutor, he's not going to be swayed by what some states decided was or wasn't a violation of their state statutes. So.
Fair enough. I yield back.
Gentleman's time has expired. Ms. Beer, you're recognized for 5 minutes.
Thank you, Madam Chair. You know, this hearing belongs in a bad episode of House of Cards. I'm sure Frank Underwood is lurking somewhere here in the room. In fact, this hearing is literally based on a house of cards, and the exhibits being used as a foundation are in all likelihood the product of a theft carried out by someone who is now under indictment in Texas and whose home has been the subject of a court-ordered search in California. Is this hearing really going to proceed based on stolen and misleading documents? Even Frank Underwood would be blushing at this point. This committee's sole purpose is to hold fake trials of citizens and companies that comply with laws, but not with the political agenda of Republicans who want to restrict women's health care. 12 states and 4 congressional committees, 1 Senate, 3 House, have already investigated the videos released by the so-called Center for Medical Progress last summer and found absolutely no evidence of wrongdoing. The same cannot be said for David Daleiden and his associates. This so-called committee is the very definition of a kangaroo court, a mock court that disregards the rules of law and justice to validate a predetermined conclusion. But this mock court has real consequences. While we are focusing on what goes on inside a woman's uterus, we are completely ignoring what happens to babies and children outside of them. How else can you explain why this panel is holding this hearing while children go hungry and research on pediatric cancer is desperately in need of more research dollars? What about the health implications for our children if we stifle fetal tissue research? After all, fetal tissue research was key to the CDC's recent confirmation of the link between Zika and microencephaly. This is the first step in developing treatment options and vaccines to stop the spread of Zika. Considering Zika-affected infants suffer from brain damage, severe seizures, and other medical problems, why aren't we talking about protecting those infant lives? If this committee succeeds in abusing medical professionals so severely that they abandon promising research, not a single life will be saved, but many, many will be lost. Perhaps we should propose a new name for this committee, the Select Investigative Panel on Stopping Research and Letting People Die. Now, let me ask Mr. Rabin, given that no witnesses on the panel have firsthand knowledge of how these exhibits were created or the underlying facts captured in any of them, do you think it's appropriate for the witnesses to speculate about
the gentlelady yield.
Criminal misconduct based on those documents?
Madam Chairman,
Gentleman is recognized.
I take personal offense to for it being said that as a physician, I'm here to allow people to die. Like those words stricken from the record. It's a personal attack on me as a physician.
You were not referenced by name. Mr. Rabin, will you please respond?
I wouldn't quibble with.
Inquiry on that?
You have to be referenced by name.
If the gentlelady will yield.
I will yield.
Thank you. You would have to be referenced by name, and I appreciate the inquiry, but you would need to be referenced by name.
Thank you. I'd just like part of the record that I'm offended by that comment. Thank you.
No
Gentleman is so noted. Ms. Spear, you're recognized.
Mr. Rabin.
Thank you. I can't quibble with speculation. It's important that everybody remember that it's just speculation, that this is not probative evidence of anything. We've got very, very bright, experienced people speculating.
So, to Mr. Lennon, the Madam Chair, even in her opening remarks, referenced, quote, horrible videos. These videos have 30 minutes missing from them. The doctor interviewed said 10 times that Planned Parenthood does not profit from tissue donations. And Mr. Daleiden sent a proposed transfer agreement with a specific clause, a compensation clause, to Planned Parenthood when he was trying to negotiate a contract. Planned Parenthood struck that particular compensation clause, and then Mr. Daleiden didn't pursue it. Is that a reputable person on which to base an entire committee hearing?
I've never met the gentleman that you referred to. In fact, I don't know what House of Cards or Frank Underwood is either. So, but I will tell you this: there's a difference. There's a difference between what a discredited whistleblower like Ms. Clayton unfortunately had to deal with, as opposed to admissions made by an agent of a potential target. So those are apples and oranges. I have not purported, I'm not saying I've watched all the videos. I've seen some excerpts. I'm just talking as an evidentiary matter. There's a huge difference between a whistleblower who is discredited and an agent or director or employee or officer of a targeted industry. Those are admissions that could be admissible in court. So I think, again, I don't want to opine. I have not looked at all the videos. I don't even know where they were all made.
My time has expired.
Thank you.
Gentlelady yields back. Dr. Harris, you are recognized for 5 minutes.
Thank you very much. Look, I'm sorry, I'm not a lawyer. I'm a doctor. I've worked, on NIH-sponsored research and at Johns Hopkins. And I want to ask today not about profit, because look, I think the record speaks for itself. All the costs were covered by the procurement companies. Record speaks for itself. But I want, on Exhibit B2, the procurement company's brochure, it says that these are IRB certified consents. Exhibit C8, page 2 in the bottom says Biomed IRB approved. And in fact, I'm going to ask a legal question here because, IRB approval is very important in human research. And if you're looking at whether someone is out to make a profit, they're going to cut corners, they're going to save $1 here or there. And so I'm going to ask a question about specifically this company called Biomed IRB. And I'm going to ask Madam Chair to enter into the record 2 letters from the Department of Health and Human Services regarding the company, one from March 29, 2012, the other from January 16, 2013. The March 29, 2012 letter actually is a letter to that company basically asking it to cease and desist from doing approvals or, in fact, anything being obtained under one of their approvals because of the shoddy work that this apparently one-room, single-owner IRB mill. That's the best way you can call it. You can look, you can go to their website, you can see their price list. I submitted things to an IRB. They guarantee that if you have it in by Tuesday before noon, you're actually going to have it before the IRB and approved that week, basically. But for $1,900 more, you can actually submit it after noon on Tuesday and have it approved that week. It's unbelievable. But what I want to ask is a specific legal question, because if, in fact, the company continued to obtain specimens under that IRB approval between March 29th and January 16, 2013, who's liable for that? If, in fact, when that IRB, when the FDA said you cannot obtain specimens, told the IRB that that's true, Mr. Lennon, who would be responsible for that?
I don't think I don't think I have a foundation to answer that
Okay.
question.
Let me ask you a question. Is it a valid question to ask? That in fact, if the FDA had said you can't obtain tissue, you can't obtain anything under the IRB approvals that you've had until you've responded to us, and the letter came back almost a year later. If in fact a procurement company was obtaining tissue in that period of time, would that be a problem because Title 45 of the regulations, Part 46, make it pretty clear you need IRB approval. And in fact, downstream federal research, where an IRB further downstream depended upon that information and that IRB to be accurate. In other words, if I was obtaining as a researcher tissue from this company, my IRB assumes that the previous IRB approval is actually valid, that in fact that company represents they have IRB approval. If they don't, is it valid to actually look downstream and see whether those IRBs were notified downstream, whether in fact those researchers were notified that this IRB approval in fact had been suspended by the FDA? Is that valid? Is that something we should look into? Mr. Norton, something we should look into?
I think that's a very valid question, frankly, and as I looked at the exhibits in preparation for this hearing, that was a question I had, is exactly what was the effect of and the date of and the integrity of the IRB approval process. As I understand Exhibit C-15, it is a document that is being provided to the woman who's
Yeah, let me go
obtaining
on.
the abortion. So I think it's a valid, because essentially it's a false statement by the...
And let me go further to a false statement. On the videos, pretty clearly, a doctor says, we modify the procedure to get better body parts. Pretty clearly. I mean, look, there's no doctoring going on here. This is, you look at it, and I urge anyone looking at this hearing, go look it up. The doctor says we alter it to preserve the calvarium so we don't crush the calvarium so we can actually get the amount of money we're going to charge for it. The federal regulations say you actually have to tell the patient if you're going to change a procedure. Now, I look at the consent forms, which is Exhibit C8, page 2. It says specifically your abortion procedure will not change in any way. We look at one of the consent forms that was actually entered into the record last time, which says that your procedure will not be changed anyway. If, in fact, the procedure is changed in any way, is that a violation of the IRB-approved consent, which is necessary for federal research dollars? It's actually necessary for any research to be conducted downstream. Is that a violation of that? If you in fact modified the procedure after the patient signed a consent that said procedure will not be modified?
Yes, I think that's also a violation of the statute itself.
Thank you very much.
May I just get in there to question the premise?
My time has expired. I'm sorry.
Well, mine is not. The premise of...
Gentleman's time has expired. Okay, Mr. Rabin, go ahead.
I'm going to question the premise of I don't know a thing about the consent forms of the IRB. I never work on IRB, but your premise that the videos were not, this part of the video was not distorted is not accurate. Every aspect of the videos that were put out in the public were heavily edited, deceptive and distorted, and independent analysis find that. And I don't think there's a sane prosecutor in the country that would feel comfortable putting people who created those videos on a witness stand in a case because they'd be impeached.
Ms. Delbene, you're recognized for 5 minutes.
Thank you, Madam Chair. This hearing, and frankly, this entire investigation is nothing more than an attempt to limit a woman's right to choose under the false guise of illegal tissue sales. And this isn't the first time we've seen this. As Ms. Clayton stated, 16 years ago, the House held a hearing on nearly identical allegations. Those claims, also based on secretly recorded videos by anti-choice extremists, were found to be fabricated and patently false. In fact, much of the so-called evidence that was used back then mirrors what we're seeing right here today. In that hearing, the majority relied upon a whistleblower who claimed that the entities were profiting from illegal tissue sales. However, while testifying, the whistleblower acknowledged that he had fabricated his statements and lacked any knowledge of illegal activity. The Department of Justice, though, still investigated the person in question, Dr. Miles Jones, and found that after a thorough review of the issues, no violations of federal statutes were found. So, Mr. Rabin, if the Justice Department had uncovered evidence that Dr. Jones had violated the federal laws on fetal tissue donation, the statute, in particular Section 289G2, would have permitted the Department of Justice to prosecute. Is that correct?
Yes.
And the majority appears to be saying that the term valuable consideration isn't fully defined, and as a result, the DOJ is incapable of enforcing the law. In your opinion, does the Department of Justice lack the clarity that they need to enforce the law?
No.
And if the department had actual evidence of federal violations in those cases, the DOJ would enforce the law, would it not?
I have complete confidence that the men and women of the Department of Justice know what they're doing and take issues like this seriously, yes.
So is it fair to say then that there really isn't a problem with the statute in the 2000 case regarding the Miles Jones investigation, but rather a lack of facts to support the prosecution?
That would be my inference, yes.
And do you think we're in a similar situation from what you've seen
Yes.
so far today?
Yes.
So do you think it's possible that the lack of prosecutions that others have referred to over the years under both Republican and Democratic administrations signals that there aren't widespread violations of the law, as we've heard alleged here today?
That's right.
So then once again, I think this hearing is really another recycled attempt to show wrongdoing when there is none or there's no evidence that there has been done. And we're once again watching history repeat itself. I'd also point out that after the investigation in 2000, women's healthcare providers were also subjected to false allegations or false accusations on seven separate occasions between 2000 and 2013, all based on so-called evidence from anti-choice extremists. I don't know, Ms. Clayton, if you have any comments you want to make about those allegations that took place afterwards.
I'd be glad to. The false allegations and the attempts to stir up crazy people like Robert Deere have been ongoing. I think they've been ceaseless. In fact, anyone who saw Mark Crutcher talking at the Cleveland Right to Life last month saw him brag about stirring up people like Daleiden, who'll go out and do his business by any means necessary. How Crutcher has avoided prosecution, I don't know, but I think it's because he gets other people to lie for him. These efforts by the radical anti-choice groups like Life Dynamics, Army of God, have been endless as far as I can tell, and they threaten the lives of everyone who uses a clinic for, and the clinics, by the way, don't provide just abortions, they provide a host of health services. The people who were murdered in Colorado weren't getting abortions. It's a terrible threat to the health and safety of the nation when these people are allowed to get away with that.
The majority seems determined to use this taxpayer-funded panel to continue pursuing the latest series of false, unsubstantiated allegations, even though they've been debunked by everyone who's looked at them, including state attorneys general, as well as committees right here in Congress. So the truth is that the investigation, and this particular investigation, isn't really about fact-finding at all. As we've talked about, we haven't had witnesses who can speak to the facts here. So these are just baseless allegations made by Daniel Daleiden, and it's just another attempt, I would say, to smear women's healthcare providers with falsehoods and fabrications. Women definitely deserve better. I yield back, Madam Chair.
I thank the gentlelady. Mr. Duffy, you're recognized for 5 minutes.
Thank you, Madam Chair. Is it fair to say that the whole panel today thinks that we should look for the truth?
Absolutely.
Does anybody disagree with that? Raise your hand if you disagree with that. Okay, and we should actually enforce the law. Does anybody disagree with the fact that we should enforce the law? So we all agree. All right, great. We're starting out very well. I've heard some conversation about how the Department of Justice and investigations, and so just to be clear on this, Ms. Clayton, has there been an FBI investigation into this issue?
I'm not privy to that sort of thing. I have no idea.
Norma, okay, so how about this? Is there a lead DOJ attorney that's been assigned to lead the investigation into this matter?
Mr. Duffy, I'm a civil litigator. I
just
have
wondering
no
if you're-
knowledge or access to that sort of information,
just
which
wondering if
I
you're-
understand has to be kept. I don't think it's allowed to be shared with people like me.
So you're not aware of any lead attorney at the Department of Justice? Does anybody on the panel know of a lead attorney at the Department of Justice who is leading this investigation?
No, I've heard nothing of
I haven't either. I want to have the panel refer to Exhibit Exhibit B2 and B3. Starting with B2, I believe that this was a document that was received from a National Abortion Provider Conference, and it seems to indicate that there could be financial profitability for an abortion provider if they engage with the blocked out middle person, right? So if we look at the statute, it prohibits valuable consideration to be paid for the transfer of body parts. Is that right?
Absolutely.
And so if someone is getting reimbursed for a body part, it's pretty tough to make a profit, isn't it? If you're just getting reimbursed, you can't make money. Am I missing something, Mr. Sakia?
I agree.
Okay. So, but if you're getting more than just reimbursement, you can make a profit.
Yes.
Does that concern anybody on the panel that then maybe the DOJ and the FBI isn't looking into this? Mr. Norton?
I think that's highly concerning. That's why we're here, to encourage this panel to do that.
I would agree with you. Ms. Foster, I've heard a lot of my friends across the aisle talk about this being an issue of women's health care. In regard to Section 42 USC Section 289, this is a section, I believe, that talks about valuable consideration for fetal body parts. Is there anything in that section that you're aware of that relates to women's health care?
There isn't. And I would add that as a woman, and in fact as a post-abortive woman, I am deeply offended that abortion clinics are permitting improper access by procurement businesses to really exploit us, to potentially place us under duress, and to put our children on display for sale in the way that chicken livers are in a grocery store. It deeply offends me.
Thank you. Ms. Clayton, I'm sure you've had a chance to look at Exhibit B2. Is it your testimony that this document has been altered in any way?
B2? I have no knowledge of any of these documents, and if these documents are anything like the videotape, I would start with the assumption that they probably have been altered. But I don't have any personal knowledge one way or the other. I never saw them until they were sent to me by email, I think it was yesterday.
So you've had a chance to look at them since yesterday. You're an impartial witness today who's making assertions that they're probably doctored.
No, I said I would start with the assumption that they might be, just because
Well, take a look at them.
I have no knowledge of them, nor has anyone in this room given any indication of the source of the documents.
Look at the
So
document.
as far as I know, they
Ms.
might
Clayton,
have
this is my
been
time.
invented, just like the
I would love to
videotapes have
see
been
you then
invented.
tell the panel today what has been doctored in Exhibit B2.
Exhibit B2,
This is the document that shows
let me
that
find it.
an abortion provider can have financial profitability.
well, actually, no, it doesn't say that at all. This obviously refers to adult
have some-
tissue as well as any other kind. This is not limited. I looked at B2, sir, and it's clear that this is talking about adult tissue, which is far differently regulated.
That is not
than
true.
fetal tissue.
It's talking about fetal tissue. It
I'm
says it
looking at-
clearly.
It says fetal
It
to
talks
adult
about-
tissue,
It says fetal and adult.
right on its face.
No,
It wasn't
says
doctored enough.
Stem cell-rich blood.
It's been redacted in certain ways that I
It
can't
says
tell what's
fetal- the
redacted.
document says
Fetal,
fetal tissue.
right here, fetal DNA.
Will the gentleman yield?
No, I will not.
Okay.
And it also talks about stem cell-rich blood and raw materials. Does anybody know when they say raw materials, what that's referring to?
Perhaps adult tissue.
Adult.
It certainly applies to both adult and fetal, and I can't tell from the blacked out
Even if it
part.
does apply to both,
To the
it's
panel.
still an offense because it does apply to fetal.
If this document is being sent out during the National Abortion Provider Conference and they're talking about adult tissue, is that your testimony today, Ms. Clayton? And we're not talking about fetal tissue?
Is what my testimony?
That this document is referring to adult tissue when it's being provided
I have
to the,
no
the
idea.
National
All I
Abortion
can-
Provider Conference?
Sir, all I can tell you is that it's clear from reading this document that it is not limited to fetal tissue.
One last-
And, sir, if I may finish
One
answering.
last question.
The regulations
One last
for
question.
adult are entirely
There's
different.
been a lot of conversation on the
Gentleman's
Hill
time has
about money
expired.
involved in politics. Has anybody on this panel
Gentleman's
made any
time has
contribution to
expired.
any of the members that sit on this panel? If so, raise your hand if you've made a contribution to anybody on the panel.
Gentleman's time has expired.
I yield back.
Ms. Watson-Coleman, you're recognized for 5 minutes.
Thank you very much. It is often said that Congress writes the laws and the executive branch enforces them. In 2000, when very similar allegations about tissue procurement organizations were made based on explosive video interviews, the Justice Department was asked to investigate. Then Assistant Attorney General Robert Rabin, you, sir, thank you for being here, responded to a request from Fred Upton, who had inquired about the potential criminal violations of the federal statute against fetal tissue sales. In that letter, the department noted that based upon a preliminary review of our records, it appears the department has not received any information meeting our standards for triggering a formal investigation that fetal tissue has been sold for profit. And I ask unanimous consent that a copy of that letter be entered into this record. Mr. Raven. Thank you, Madam Chair. Mr. Raven, can you explain what these standards for triggering a formal investigation are within the DOJ and why these standards are necessary, and have these standards been met in this instance that we are debating now?
Why these standards have not been met?
What the standards are.
Yeah.
Why should they be met?
Right.
What
There's two-
triggers this?
Sure.
And are we there now?
Extremely briefly, there's different levels that all investigative and prosecutive agencies go through. There's an initial investigation, which can be begun with, any credible data. There's a formal investigation, which requires a supervisor to sign off for the use of resources. And then it's working with a prosecutor to figure out whether, with a whole range of criteria, including sustainability of a conviction, are there other jurisdictions that could take it? So I can refer you to the AG guidelines and the FBI guidelines, and I can get that to you subsequently. But to answer your question, it could well be that an agency is involved in an investigation. We have on the record 12 states that have opened an investigation and closed. We have on the record 8 state officials saying they wouldn't even open an investigation based on the evidence that they have. So I wouldn't be surprised if the department has looked at it and declined. And as I've stated before, the central problem is there is so much duplicity and deception around how so much of this evidence was created that I think it would give most prosecutors pause to go forward with a case.
So as in the Delightin videos, the deceptively edited videos, and sort of the out-of-contact invoices, would they be enough to trigger a DOJ investigation?
It would be an investigator and a prosecutor going with incredible caution. He or she would have to find, in my view, probative and credible evidence from other than that source.
Right, and so would it involve also determining the validity of the Delightin investigation, allegations?
It's bad facts.
So it would be, I'm sorry.
No, go ahead.
Thank you. So it would be important to at least have a conversation with individuals with actual knowledge of the facts contained in any documents under review, any
Yes.
requests for investigation.
Yes.
Here today, you've been asked by my Republican colleagues to opine about possible criminal misconduct based on a slew of documents that were sent to you late Monday afternoon without identification of the author of any document, underlying source of information the documents contain, and without the benefit of speaking to anyone with firsthand knowledge of that information. Is this, in your opinion, a fair or legitimate way to determine if there's been a violation of federal law?
No.
Madam Chair, unlike the Select Panel's investigation, DOJ must base its investigations on real facts and hard evidence. This panel has instead based its investigation, and I put that in quotation so far, on an indicted extremist and his discredited videos, and it is certainly a time for the majority to rely on facts, not inflammatory allegations of anti-abortion extremists. And with that, I would just like to ask Ms. Clayton one question, and that has to do with adult tissue versus fetal tissue. You wanted to say something with regard to that, and I want to give you that opportunity, because it is clear that wherever that particular slide comes from, it does refer to both.
From my experience 16 years ago, representing a foundation that provided both fetal and adult tissue for medical research, I know a little bit about it. My knowledge is out of date, but among the things I know are that fetal tissue donations are highly, highly regulated, as are donations of fetal or adult for transplants, very highly regulated. When it comes to adult tissue that's just for research, there are still regulations, of course, but far fewer. So when I looked at that exhibit, what was it, B or something, I immediately saw they were, the exhibit, assuming it's a real document, was conflating more things than one. It wasn't just about fetal. It was
about a
clear.
range of
yeah,
services.
And so if you talk about what you can, if I die in the Amtrak and my liver goes to somebody, you know, they can do a lot of things with that, not highly regulated.
Thank you,
But-
Ms. Clayton. Thank you, Mr. Rabin, and thank you, Madam Chair.
Thank you. The gentlelady yields back. Ms. Hartzler, you're recognized for 5 minutes.
Thank you, Madam Chairman. Nobody should make a profit from the sale of baby body parts. That is something that is shared by the majority party as well as the minority party. I want to remind everyone that back in 1993, when this was first introduced in Congress, the idea of this, Henry Waxman, who introduced the amendment, a Democrat, said it would be abhorrent to allow for a sale of fetal tissue and a market to be created for that sale. And yet today we have seen that the procurement organizations in Exhibit 1, 2, 3, and 4 are receiving $700 to $850 per brain. But I want to focus on the abortion clinic's part in this. Could we look at Exhibit D1? Here are the payments that we have obtained to various abortion clinics for these baby body parts. We have Fresno having 38 specimens, and they received $2,090. Sacramento Abortion Clinic received $3,740. San Jose, $3,575. Now, nationwide, the panel investigation has found that there are many more of these middleman procurement organizations, and there are hundreds of abortion clinics. And I remember some of the abortion clinic doctors on the video that Mr. Sakaya referenced talking about making money from the sale of baby body parts, even joking about it. So I want to hear from the former U.S. attorneys, given their training and experience, how they would investigate the accounting records and anything else to document whether the abortion clinics profited for the sale of baby body parts. So, Mr. Sakaya.
Yes, ma'am. Thank you. I have some experience both on the prosecutive side of this, not just being a former prosecutor for 13 years as an AUSA and then a few years as the U.S. Attorney, but also in my experience fighting Planned Parenthood in a very grueling 8-day trial, one of the few in the country, on the defense of Florida's Parental Notice of Abortion Act. And I will tell you that follow the money is a concept that applies with special force in that area. And that was, it was astounding what I learned about how money motivates that industry. And when I look at these figures, let me give you an example. One of the doctors that testified acknowledged that he had performed over 100,000 abortions. We, based on the amount of time that he, well, the only way we could do it, because I continued to try to find out how much are they making. And they fought tooth and nail to prevent that information from coming out. So to quickly just answer your question, I would say yes, it's extremely important to find out where the money
What
goes.
specific documents would you look for?
I would ask for bank records.
Okay.
I would find out what, follow the money. I'd find out where, who's getting paid, where are the checks going?
Okay, thank you. Mr. Norton.
Yes, I would do the same. First of all, I would start by looking at the videos, which I have seen. I would start by reading the forensic accounting report by Coal Fire Investigations, made up of former FBI agents, which found that the videos were credible and the redacted versions say what the longer versions say. I would obtain the accounting records, the financial records of the abortion clinic, of the procurement business, and frankly, I would obtain the records of the end user as well, and subpoena both records and witnesses from all of those entities to flesh out the facts in this case, which I think are there.
Great. Thank you very much. In the last minute, I want to turn to Ms. Foster and ask you a question. As you've just testified, post-abortive woman, please explain a little bit more about what you think regarding possible HIPAA violations that Mr. Norton raised, where the procurement tech has the ability, after receiving the order through email in the morning, to review the medical records of the patients without their knowledge. Explain what you think. Has HIPAA been violated, and if so, what should the penalty be?
I'm very concerned that HIPAA may have been violated. Obviously, Planned Parenthood has gone to court time and time again to keep secret and confidential the records of women who have abortions, and yet these very same abortion clinics are allowing procurement businesses into their doors, sharing records, and allowing them to find out some of the most personal health care information imaginable. So that obviously is an extreme concern for me, and something that I definitely want investigated.
Thank you for sharing that. Certainly, we are here because we care about the women, too. Make sure they are not being manipulated or hurt in any way. Thank you. I yield back.
Gentlelady yields back. Mr. Nadler, you're recognized for 5 minutes for questions.
Thank you, Madam Chair. Just when I think my Republican colleagues cannot find a way to make this investigation more of a farce, we have a farcical hearing like this one. None of the documents the Republicans are showing today contain any evidence of wrongdoing. In fact, these misleading documents, many of which the Republican staff produced themselves with no basis in reality, do not provide any foundation for an investigation of this nature. Cutting and pasting sections of draft contracts that were never signed or formalized, creating charts and graphs with no analytical basis, and printing off random invoices with no explanation for their contents does not meet the standard of evidence for any court of law, let alone for a congressional investigation. I would think the Republicans should have learned this lesson after the mess of a hearing in 2000, when a tissue procurement organization, a TPO, then stood accused of profiting from the sale of fetal tissue research. The source of these accusations? Heavily edited videos produced by anti-abortion extremists. Some of the same documents we are looking at today were tossed around by the Republicans in 2000 with the same misrepresentation of the facts. As we all know, that hearing fell apart when the key witness, Dean Alberti, the man who accused the TPO of profiting from fetal tissue donations, admitted under oath that he had lied in the videos. Suddenly, those invoices and the fee schedules didn't seem like such a smoking gun. Well, they weren't then, and they aren't now. Yet here we are again. This hearing is another example of the Republican majority going to extreme lengths to advance their dual agendas of smearing organizations against whom all federal and state investigations have found no evidence of any violations of law, knowing that the smears will endanger the lives of people who work for these organizations. And that's why I've said that this committee is worse than McCarthy investigations, because McCarthy endangered people's lives. This committee, endangered people's jobs. This committee is knowingly endangering people's lives. And their other goal of eliminating women's choices and degrading their doctors. Now, Mr. Rabin, I'd like to ask you a couple of questions. We just received yesterday we received a letter from the Council for STEM Express, who informed us, and I quote, "It appears that the majority staff may have repurposed unauthenticated, stolen documents illegally obtained by David DeLayden and the Center for Medical Progress, and that some of the majority's exhibits have never appeared publicly, suggesting that perhaps the select panel may be receiving so-called evidence directly from Mr. DeLayden or his associates." Does that not call into question the validity of the entire investigation, or at least what the majority appears to be relying on?
It sounds like bad form, yes.
More than bad form, I would think. And what do you think of the refusal by Republicans even to question Mr. DeLayden or to test the credibility and objectivity of his allegations? What should that tell us about this investigation?
I'm not going to comment on my good friends across the aisle, their motivation. What I am concerned about is, whether the point of this hearing is to politicize an investigation and to press DOJ to do its job in a way different than they think they ought to do. I think there's a very sad history of that, and it's always dangerous.
A history of using congressional
Yes.
pressure to
Yes.
press prosecutorial decision.
Yes, it's one thing to refer information and to have comedy between the branches. It's another to use politics to pressure a particular agent or investigator into doing his or her job.
In that connection, isn't this entire hearing, this entire investigation, having no purpose essentially other than to suggest that since it's obviously that these organizations are guilty of what they're being accused of, that the DOJ and the various state investigating agencies have not done their job properly if they haven't brought indictments?
That's the implication.
Thank you. And let me ask you this. We've heard before that Mr. DeLayden was indicted only for a false identification, and every college kid, or not every, but half the college kids have false identification, so big deal. But 18 U.S.C. Section 1001 criminalizes any person who knowingly submits false material to Congress in connection with an investigation. And I think, and I'd like your comment, from what we've seen and what we've heard in this entire thing, that does seem to be a serious problem, that Mr. DeLayden and the Center for Medical Progress were submitting knowingly false information to Congress, and that's a very serious problem.
Yes.
Ms. Clayton, would you comment on that?
Oh, I agree completely. And what Life Dynamics submitted back in 2000, I've always wondered why they didn't get prosecuted for it, because it was an admitted fact by the guy they hired. That's who the DOJ should be going after if they have time.
In summary, we have the refusal by the committee who are making all sorts of accusations against STEM Express. We have a refusal by the committee to talk to them, to ask them for explanations. Then we have the committee, apparently taking, directly or indirectly, material from Mr. DeLayden stolen from the STEM Express website without asking STEM Express whether, and that material seems to be doctored, all to say that STEM Express and other similar organizations are doing illegal activities, but you don't want to talk to them and see if they have an explanation, and you do take apparently false material stolen for that purpose in order to pressure the DOJ. Is that a fair summary of what seems to be going on?
Yes.
Is that a legitimate function of Congress?
I'll repeat what I said, that the concern that I have after 20-some years of being on both sides of it is when a congressional gavel is used to intimidate or pressure an investigative agency to take action that they think it ought to be taken, particularly in the face of now 20 states. 20 state officials, nonpartisan, have said on the record they've looked into this or related facts and declined to go forward with prosecutions.
Thank you very much. My time has expired.
Ms. Love, you're recognized for 5 minutes.
Thank you, Chairman, and thank you to the panel for being here. I want to contrast and focus on two different things, organ donations and fetal tissue donations. First, many say that organ donation is a gift that one can give. It's a beautiful thing when you think about somebody donating their organs. And organ donations are done with dignity, disclosure of where and how the organs will be used. And in every hospital in the nation, there are uninfluenced counselors to help with the process, and no money is made from the organ donation. The process is transparent and seen as ethical. On the other hand, when it comes to fetal tissue donation, it's different. A scared, vulnerable woman, including a minor who's underage, can come into a clinic on the morning of her surgery, and first she needs to give consent to the procedure without any parental guidance or anyone there. Then before the event, before this invasive procedure, a tissue technician comes to her and gets her to donate her baby body parts. Instead of an unbiased counselor, the tissue technician may be focused on making a commission rather than protecting that woman's best interest. It is not transparent how the fetal organs will be used or by what organization. To me, the contrast is astounding. It is ethical. It is unethical for this procedure to happen this way. So my question is, who protects the woman's interest in each case? Who protects the minor's interest in this case? There are no existing laws related to consent for fetal tissue donation. how many organs are needed, how much will be paid out for each body part, and as a mother of 2 teenage girls, I am absolutely astounded and outraged that we don't have laws in place to protect our minors. Mr. Lennon, why is there uniform law for organ donation in every hospital in this nation and an entirely different practice for donations of fetal organ tissue?
I don't know, and I would have to speculate. That's a good question.
Mr. Is it
Sakaya.
Sakaya?
Yes. My father was Persian and came here. He was actually from India, but his people were from Persia. And my cousins all say, "Kenny, you're pronouncing it wrong. It's Sakia," you know. But so Sakaya. Yeah.
Is there any evidence that, if there is any evidence that a law is being broken or suggestions of profiteering from baby organs, should there be investigations to ensure this, that this is not the case?
Yeah, and I thought that was the focus of this hearing, which is to ask of a federal prosecutor, if you had this information, would it justify a thorough investigation to ascertain those facts?
That's right. At the end of your comments, you mentioned that it is actually the duty to investigate to make sure that laws aren't being broken.
Yes, ma'am.
Thank you. Ms. Foster, I want to point out 5 immediate differences when it comes to organ donation and fetal tissue donation, and ask why there would be such a gross difference. And I want to ask your thoughts after you hear these 5. First, organ donation is done with protections and advocates for the donor and or the person giving consent for the donation of the organs of a loved one, sometimes that is already deceased. There is no profit being made or monies exchanged with organ donation. Furthermore, if there was any evidence of such, there would be great cause to investigate. 3, there is never a minor under duress having to make these decisions alone without the consent or advocate of an adult or for any operation procedure, let alone an invasive procedure. Furthermore, a minor would never be in a position to make the decision to donate the organs of another person. There is no contact when it comes to organ donation between the recipient of the organ, the physician procuring the organs, or the transfer team with the consent giver, the transfer team of the consent giver, before the consent is being given. And the HIPAA violations would never be allowed when it comes to organ donation. So I want to ask you this. If you are ever in a clinic sitting in that room, understanding that those protections are different, who is there advocating for you?
In an abortion clinic?
Yes.
No one.
No one. Now, furthermore, who is there advocating for a minor who this country would not let get behind the wheel of a vehicle, would not allow to vote, would not allow to join the military, would not be allowed to smoke, would not even be allowed to join a gym because there's a financially binding contract?
No one.
No one.
Gentlelady yields back. I recognize myself 5 minutes for a question. And as a reminder to my colleagues, I'll leave myself to last in the questions so that everyone's clear. I want to just go back to a couple of comments that were made, and I do have a couple of questions for you all. The pricing documents, the Exhibits D, we looked at some of those on the pricings of items, brains, things of this nature. If you're looking at a customer paying, say, $2,000 for a brain, and over the course of the year, that customer is paying $42,000 for the body parts, it is hard to imagine how the procurement business is operating at a loss. And what we are seeking to do is to figure out if there is a violation of the law and if someone is selling these fetal tissue parts for a profit. And that is what we're digging down on, is we're looking at the pricing of fetal tissue represented in those D-series documents. And then it's why we have constructed the chart, the G chart, that shows where there seems to be movement of the money. So you all have heard this debate. You've heard it from both sides. You've heard the questions coming from both sides. And I am going to start, Ms. Clayton, with you and work my way down to Mr. Sakaya. Very quickly, what I would like to hear from you. What documents would you request or subpoena from these procurement organizations in order to find out? We have asked for banking records from the procurement business that has been the point of discussion today, and they have refused to give us those. We thought that would help clear the way, if you will, to figure out what the profiting is. So let's start there very quickly. We've only got 2 minutes and 45 seconds left.
I would start with accepting the invitation from the procurement business. I understand its name is STEM Express, and I'd have them come in, put them under oath, as I understand they've offered to do, and ask them, how did you come up with this charge? Why is it so much more expensive?
That would be an incorrect assumption, but yes, we agree. We would like to have
the second
those
thing I
records.
would do is ask them in each particular case, what aspect of the actual costs does a particular clinic incur? For example, does the clinic provide space? Does the clinic, as we've seen in your charts, provide the blood draws, which requires a technician, perhaps a nurse, materials? Does the clinic have to do paperwork, and if so, how much? And therefore, how much of the actual reasonable cost is incurred by the clinic itself as opposed to by the procurement business?
Okay.
That's where I would start.
Okay?
Similar, sterilization of equipment, what's the cost capital of the equipment, the processing, the preservation, or their transportation costs? I wouldn't look at banking records. I'd want to, it's an HR function as well, staff time for the consent forms that are put together.
All right, Mr. Lennon?
As I said in my opening, you need a forensic, if I was a prosecutor, you have to have a forensic evaluation and accounting of the procurement business, because that's not clear from the records here. So following the money, you got to have the
Okay.
entire picture.
Mr. Norton?
The first thing I wouldn't do is ask the STEM Express or others, are you innocent or guilty? Every defendant I've ever prosecuted or even represented has claimed innocence. That's just not the case. There is some culpability here. I would do the same thing. I would get forensic accounting. I would get all the financial records. I would get the profit and loss statements, the income and expense statements, and I would get people under oath before a grand jury. Letters are not particularly valuable.
Ms. Foster?
There are two things that I would specifically seek among many different documents. First of all, financial records. That's something that must be brought to light. And second, women of every generation are unique human beings who can speak for themselves, but the baby body parts profiteers have created a market in which their profits rise if they pressure and coerce women into signing donation consent forms. So I would want to find out exactly what their procedures are, what documents, what training they have on how to speak to women and how they get those consent forms signed.
Mr. Sakaya?
I would just echo the comments of the other members on the panel. I would note that in the case that I handled, many of the minors were under. There were reports from people who owned and ran clinics that many minors would be under the age of 14, who often would cry out for their mothers and so forth. They're in no position to give meaningful consent, such as those suggested by the exhibits that were presented here.
Thank you. My time has expired, and I yield it back. I ask unanimous consent that the members' written open statements be introduced into the record.
And Madam Chair, we've provided you a packet of materials to be entered into the record and ask unanimous consent that those be made part of the record.
So ordered. And we also will submit the document binder, ask that that be submitted for the record and that staff make the appropriate redactions. So ordered. We will also submit an article from the Sacramento Business Journal from Kate Dyer, the founder and CEO of STEM Express. That will go into the record with the ranking on STEM Express by Biz Journals. We also would put into the record a screenshot we pulled from STEM Express's website just this morning, which still has the fetal tissue cells components in.
Madam Chair, have we reviewed that document?
From this morning, no, you have not,
Yes.
because we pulled it this morning, but you're welcome to look at it.
I'd like to look at it.
Yes, so ordered. We also have the
Well,
sourcing
wait a minute.
of
Well,
the.
I'm going to reserve the right to object.
You can
Is that
reserve the right, and we will come back to that one. We also have the source of exhibits that we will put in the record with the exhibits so that you will know where they came. There was a question on Exhibit B5, the chart that showed the growth of the procurement business's revenue. That came from Business Magazine articles and the Congressional Research Service, so that you all are aware of that. And then there was also a question on Exhibit B4. That chart with the growth in the number of abortion clinics, that information for that chart came from the procurement business owner and a contract with the abortion organization. So ordered.
Madam Chair, I withdraw my reservation.
It is submitted.
But I will also say but I take umbrage at the last statement you made about that last document. It was never ratified. That contract was never ratified. It was a draft. It says that on your specific.
Right. The sourcing. This is what we're putting into the record with the document.
As you know, we've already litigated that, and I object to them, but,
Yeah.
you overruled it.
With that, the hearing is adjourned, and I thank our witnesses.
Nice to meet you.
Nice to meet you.
So sorry to hear about your family
Thank
health
you.
issues. I know
Thank
we're all
you.
getting older,
Yeah.
we're dealing with